Well, good morning, good morning, good morning. These bars do not look good this morning. I'm already coming through as yellow. So if anyone is in the chat, I think I saw Rocket Couch just coming in. Hopefully, if you're not driving, you can type and tell me if I'm roboting. It looks like it's coming back up, but aye, not a good way to start the morning. I don't like that. Oh, it looks like it's popping down. Well, okay, let me get this feed up. I hope everybody had a good sleep. Seems like we were all just here. Oh, thanks, Couch. I appreciate that. I do. Hello, Charlie Hobo. Good morning. What were your thoughts on the cross-examination by the prosecution? Well, you're coming in swinging, and I don't blame you because that was on my mind a lot. I'd like to know what you think too. I'd like to know what everybody thinks, but I actually think it was a bit soft. Um, and perhaps it was a bit soft based on the context of what the defense had first laid out. That big stack of photos, the abuse, the stories that she was saying. I kind of can understand how they wouldn't want to come off too aggressive. But there were questions, and I had questions. And, well, to be honest, I still do. And I wish some of them got answered. Um, hey, Kyle's Goldfish. Good to see you. Good to see you. Good morning, Sue. I see Mousy and Mrs. Cassandra were already here dropping off some love and some otters. If you guys are still here, good morning. Good morning. I know you're both busy. It's nice to see you, Kyle. I Ms. Goldfish, I know you're busy too, but it's good to see you here. And actually, I'm going to go into Twitter and grab your 10 questions because I kind of feel the same way you do that there was some groundwork they could have laid easily that they just didn't. And I wish they had. Because there's some legalities, that Miss Boone broke that they could have got her to discuss and actually admit to and remind the jury about while they had her on the stand. To be honest, um, I think it does go the other way to where the jury just gets very very sympathetic for Miss Boone that it's gonna be Mr. J who's gonna have some regrets here. I mean, Mr. J has gotten increasingly snarky with the defense. He and the defense, have been going like head to head. There's been, some stuff back and forth. He's extremely annoyed with them in regards to discovery and them taking advantage of the judge's good graces. The judges ordered it, they just don't. Then they don't bother till the last minute. Um, an example would be yesterday with the 550 pages of medical records of Jorge Torres that they were told to dwindle down days and days ago. And Kevin Beck, was supposed to do that. It came to discovery yesterday, and they were supposed to have that done by 5 o'clock yesterday. They wait until after the judge brings it up after 5 o'clock to disclose they're not going to be using it. And to tell Sarah Boone that, like right that, they've been telling her all along. They could have told the state that at any time when they decided. I do not think they decided that moment right then. The reason it wasn't done is because they weren't going to use it, but they just left they don't even bother to clean up the loose ends or to let anybody have the information. Not the judge, and definitely not the state. That's just like, it's either really sloppy lawyering or it's the I know that they're behind the 8 ball and they're doing what they can. They came into this case late. There's 3 of them though. Okay. And I'm sorry. When you're under the 8 ball, you get more organize. You get more people involved, you have a plan, and you get more organized. You don't just throw stuff willy-nilly all over the place. Like you have to actually, double down on the schedule, double down on what needs to be done. But no, not these guys. You know, not at all. And I know they're behind the eight ball, and I know that they're doing the best that they can for Sarah Boone, and I want her. I regardless of how I feel about Sarah Boone and how annoying she is, I do want her to get a fair trial, just like everybody, And I do actually think that these guys are going to do what they can, for her. And all in all, they really are doing the best that they can. And I do apologize for how scrappy my voice sounds today. Okay. I think I've got all of these up now. I just want to make sure that I have this up so I don't miss anything. Okay. There we go. Let me make sure that I don't have them muted. Make sure that's all. Okay, so we can hear when they come in. But anyway, last night, because I'm always up in the middle of the night. Yeah, it's me. Morning, Purple. Good morning, tomorrow, kiddo. Good morning, Charla. Yep. Good morning. Good morning. Okay. Could the prosecution have brought up the fact that the abuse went both ways? I thought that was a bit weak. Yeah. You know what? I agree. I mean, I totally agree. It didn't come up, Good morning, Karen. It didn't. And I'm gonna just read you what I saw on Twitter with Kaya. And Kaya had put out these 10 questions. I'm not going to show them to you. I'm just going to read them to you because I already have the feed up and I don't want to miss, the first few minutes of the lovely Judge Kraynick. Okay, we got 4 minutes. Okay. So Kaya put this out. How the prosecution should have ended Cross, so Sarah Boone, in 10 questions. And here they go. And this is, let's just pretend I'm Will J. Like my voice is kind of rough. Let me see if I can summon the snarky attitude of our ADA here in dealing with the defense, in dealing with Miss Boone. Okay, so Miss Boone on the stand. I'll be ADA Will J. Number 1, your testimony today is that it started out as a joke and you were both laughing, correct? Number 2, then after taking the video saying F you and this is what it feels like when you cheat on me, George then began threatening you of what he would do if he managed to escape from the suitcase, correct? You were then scared for your life. You zipped him in, hit him with a bat to stop him getting out, and went to bed, correct? So weren't you afraid that when he got out, as you've admitted you thought he could, as you left space for his fingers, he would come upstairs and carry out his threats? You listed previous acts of violence where you called the police for assistance, correct? Your testimony today is that you were afraid for your life and thought if he got out, he would carry out these threats and you thought you were going to die, correct? So you intentionally left him in the case and went upstairs, correct? Did you barricade yourself in your bedroom, as you've admitted today you had done previously, because you were afraid? You were afraid he would escape from the suitcase and carry out these threats of violence, correct? So instead of going to bed and leaving him in the suitcase to die, you could have gone outside and called the police to report these threats and that you were in fear for your life, correct? End of cross. Now, after every correct, Sarah would have had to say yes or no. And all 10 of those, she had to say yes because it's all stuff she said before. She has admitted to the criminal acts of zipping him in the suitcase with or without his permission. She restrained him. He then asked to get out. She doesn't let him. She admitted to hitting him with the bat. She admitted to doing all of that and then going upstairs and going to sleep. And she did all this when she was feeling imminent threat, but she didn't barricade herself in. She did not call the police as she had done in the past, nor did she go to Brian's to be safe. She went upstairs and went to sleep. What kind of imminent threat is that? I hope the jury's asking these same questions in their mind. I do. I do hope that they, not that, I automatically want her to be guilty no matter what, but I do hope they at least have the questions there. I know I had a lot, and I wish Mr. J had addressed some of them. I don't know what his strategy is, but I'm sure that we're going to see more. Today, we're going to be with the defense, though, and the defense is going to be putting up witnesses to help corroborate Sarah Boone's statement from earlier. Good morning, Juju. Good to see you. We can see Sarah coming in. And I do see that you guys, I hear that you can hear the white static noise like I do, so I apologize. I can change the view, so that's a little different. Maybe you guys won't hear it as much. Nope, it's still there, really loud. What I can do, what I'll do, because it's so loud, is I'll turn it down until he comes on. How's that? And then we'll still look at it to make sure when we see the judge, because he's going to come on. It's 9:01. As soon as she's seated, he's probably going to get rid of the white noise machine. Okay. Is Boone at least subject to recall? I think so. I think for rebuttal, they all are. They can impeach. I know Mr. Henderson made some flowery remarks at the end yesterday about calling back the detective for impeachment. Again, so we'll have to see about that. I wish I could lay on the couch all day and hang and chat. Why is life always always lifting on us? I get it, Juju. I wish I could lay on the couch today too, even though I'm just going to be pushing buttons and talking to everybody. But damn, was I knackered yesterday. That was a long day, a very long day for me. And you can hear it in my voice. Like I'm not ready. Hopefully you guys weren't looking for silky smooth today, because I'm rough. I am rough. Technically, they don't need her on the stand to bring those things up. This is also true, Rocket Couch. Thank you for saying that, because the 10 things that I read, they don't necessarily need her to agree to. But it would have been nice if they heard it from her that there's no contest there, that is actually the facts of the case, correct? And, I love that, correct? With the question mark at the end. And I thank you, Kaya, for typing all of that out. And we're going to see how the rest of it plays out today with expert witnesses. Now, they had said there were some police officers that were going to testify this morning. They do have expert witnesses. They have Bannon. They have Dr. Bannon, and they also had Dr. Julie Harper. Now, there was a little bit yesterday about whether Dr. Julie Harper would be available today to testify. She might be available, but if she hasn't met for her deposition with the state, which isn't scheduled till tonight, by the way, or last night, they could have done it last night. The state was actually asking for last minute rescheduling at conveniences, even though it's on the books already with the state. And the state was like, no, I got it now. It's going to be that night, and then she can come in the morning, so we'll see. But it looks like the state will have their rebuttal Friday. If not Friday morning, then Friday afternoon. But it looks like we could actually have this to a jury for the weekend. And, and that's interesting because if they end it on Friday, juries feel a certain way. They could deliberate into the night a little bit and want to have the weekend to themselves and be done with this. Okay. Remember, we only have 6 jurors, but it also has to be unanimous. Okay, for guilty. And it's murder too. And I don't see a lesser charge yet that they can actually convict her of. I don't know. We'll hear it in the jury instructions if there is. If they are able to actually convict her of a lesser charge of manslaughter. Which, don't groan, Juju. I feel you. You and I have been talking about that since day one. That we just really think that this was a slam dunk on manslaughter, and we wish she took the deal. Because everybody all along has said, well, if she's screaming no intent, well, there are certain facts. He was in a suitcase. He did ask for help. You didn't help. He did die. You may not have intended it, but these are facts. And that would have been some accountability, and Juju and I would have been very happy if that had just happened. I'm sure many of you would. And we wouldn't be sitting here today wondering what the heck is going on with this child. Okay, but those aren't the charges. Based on her lying, based on her change of schedule, based on the previous history of abuse where they knew she had been aggressive, they didn't buy this. I don't know what happened. I don't know what happened. I don't know what happened story. And rightly so, because as of yesterday, she had remarkable memory recovery for certain areas of the night, but not others. I don't remember taking the photo of the suitcase. Oh, but now I remember taking the video. Oh, and those 9 minutes you don't get to hear between those 2 videos, that's when he was violently threatening me and trying to get out of the case and being all animated. Except, like, during the first 2-minute video, we heard him barely able to call out. How did he get so much energy all of a sudden to do all of that? We also saw her struggle with that zipper. We saw everybody struggling with that zipper. We're supposed to believe that 2 bottles in, drunk, because she says that after she came down there and zipped him, it was not that long that she sat on that couch and made that video. And we heard the state she was in with the consumption. She was slurring her words. She was agitated. And we're supposed to believe that they were laughing 3 minutes before that. I don't know. I have questions. And here's the thing, like, and I even feel bad that I have so many questions, actually, I do. Hey, Charlie Hobble, thank you. Thank you I'm going to put this in the coffee phone, and it's my privilege to actually speak about this case and several other, and thank you for being here. I do appreciate the nod of appreciation. They are long days, and it's nice to know that they are actually, for some of you, really, really appreciated that you got a place to talk, and we get to talk the real deal. I'm not no fancy lawyer. Everybody's opinions are welcome. I like having the just regular conversations about it and actually looking stuff up. Like, I want to be informed, and I want to speak with other people about it. I want to speak to lawyers about it. Oh,
right, good morning, everyone.
Oh,
Madam Clerk's going to go ahead and call
give it to the judge. Good morning, Judge Kraynick.
Dick Ketchner on behalf of the state. William J. for the state.
James Phillips for Ms. Boone. Tony Henderson for Sarah Boone. Kevin Beck for the
Ms. Boone, raise your right hand, please sworn, please. Do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
And good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Ms. Boone is seated at counsel's table wearing a dark gray suit jacket and a maroon blouse. She is in custody. However, she's not in any restraints, so we will be continuing to stand as our jury enters and exits. State, are there any housekeeping matters we need to address this morning before we bring in our panel? Defense.
Judge, I don't know if you got an email last night of the potential witnesses we're going to call.
In addition to the one I received this morning. Yes, sir.
Dr. Harper did get in last night after midnight. She's over at Koepsell, but in addition, we may recall the phone extraction expert. She's not on the list.
Okay, understood. All right. Are we ready to bring in our panel?
Yes.
Okay. All right, very good. Let's go ahead and stand and bring in our panel.
Well, good morning. Good morning. Juju, I've got some good instincts too, and they're not very good. In Rocket Couch, I did see what you typed, and I think that those questions that we went over, yes, they can come up when the expert witnesses are there. Maybe we will hear them in cross-examination of several of them. Yeah, Kyle's goldfish, I hear you. I'm wondering how much of that was sympathetic. I do believe we have 4 women, 2 men, or it could be 5 women, 1 man in the original 6 seatings, plus the alternates. We do have quite a mix. Okay, and I'm wondering how it went. Because you are right, it only takes 1 juror. And we do have juror number 13, who is a woman testifying against her husband in a domestic violence case currently. And it might be personal, And but the bias could go both ways. She could actually say, like, that doesn't relate to my situation. Like, they could possibly see through it based on that they're so close to the situation. I watched Dr. Berry last night too, Juju. They did have some good insight, and they were right on board with many of us. The pictures were sad. They were horrible. And I don't doubt that there has been abuse in both ways in that relationship. I really don't. Charlotte says, can you imagine if it was your son or family member? Yeah, I feel the daughters were in the court and watching that yesterday. But they didn't have much of a reaction, according to Twitter. Yeah, she was nodding her head, Charlotte. Yeah, they said she was taking notes too. And I don't mean the daughter. I mean juror number 13, the one with the DV.
State, do you recognize our jury?
Yes, Your Honor.
Defense, you recognize our jury? Yes. All right, everyone can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. I hope you had a great evening. If you could, again, just by a show of hands, you complied with the court's instructions for the overnight break. Record reflect all hands have been raised. Members of the jury, at this point in time, the defense is going to continue with their evidence and testimony presentation. And I'm going to ask them to call their first witness at this time. Mr. Owens, you may proceed, sir.
At this time, the defense calls Deputy Ramirez-Delgado.
Okay, our first witness is the deputy. I agree, Juju.
Good morning. You can be seated. And can you please state and spell your name for the record for me?
Yes, sir. My name is Jessica. First name Jessica, Jessica. Last name is Ramirez, Ramirez. Second last name is Delgado, Delgado.
Thank you, ma'am. You may inquire, sir.
Good morning, ma'am.
Good morning, sir.
Ma'am, how are you employed?
I am a reserve deputy with the Orange County Sheriff's Office.
And how long have you been employed with the sheriff's?
7 years.
Back on July the 25th of 2018, how were you employed at that time?
I was a full-time deputy sheriff for the agency.
On that date, ma'am, did you have the occasion due to your duties to report or to go to 4748 Franks Lane, apartment number 3?
Yes, sir.
Do you recall what you were going there for?
Yes, sir. I was a backup deputy for a call involving a male kicking a female in the face. So it came out as a domestic call.
Okay. And was it another officer who also responded?
Yes, sir. He was the primary.
Okay. Ma'am, while you were there, did you have contact with Sarah Boone?
Yes, sir.
While having contact with Miss Boone, were you able to observe any injuries?
Yes, sir.
to her person?
Yes, sir. She had swelling and bruising in her right eye.
And ma'am, were you able to make contact with Mr. Jorge Torres?
Yes, sir.
Were you able to notice any injuries on his person?
Yes, sir. He had red markings and some abrasions around his neck.
Ma'am, at a certain point in time, did you place Miss Boone under arrest?
Yes, sir. I detained her and placed her in my vehicle.
Ma'am, at that time, do you recall or remember Miss Boone asking you, why am I in trouble?
Yes, sir.
And without saying what you said, but did you respond to her?
Yes, sir.
After that, ma'am, do you remember Miss Boone asking you why? Because I fucking fought back.
Yes, sir.
Yes, sir.
No further questions.
Thank you. Any cross-examination?
During the course of your investigation, you or the other responding deputies spoke to Mr. Torres as well.
Yes, sir.
After concluding all of your investigation, which involved talking to both Mr. Torres and to Ms. Boone and making your observations of the two of them, did you all make final decisions about how to handle your investigation?
The other deputy, which at the time was Deputy Zito, was the one that made that determination.
Okay, but collectively, what you all looked at was statements from Ms. Boone and Mr. Torres, correct?
Yes, sir.
And your physical observations of both persons?
Yes.
And then whatever else you may have observed on scene?
Yes, sir.
And do you take into account people's demeanor when they are giving you statements when assessing their credibility?
Yes, sir.
No other questions?
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Yes.
All right, thank you.
Thank you.
Well, that was short and sweet.
Defense, call your next witness.
Oh, I gotta take those off.
At this time,
Buddy.
the defense calls Deputy John Alden.
All right. Sorry about the closed captions, guys. I got it. I didn't notice. Exactly, tomorrow, kiddo. Just getting it on the record.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, good morning. Can you state and spell your name for the record?
John Alden, Johnalden.
All right, thank you, sir. You may be seated. Mr. Henderson, you may inquire.
Good morning, sir.
Morning.
Sir, how are you employed? How are you employed?
I'm employed with the Orange County Sheriff's Office as a corporal.
Back on August the 28th of 2019, how were you employed?
I was a deputy in Uniform Patrol Division in Sector 2.
As a part of your job duties that day, did you have the occasion to respond to 4748 France Lane, number 3?
Yes.
What was the purpose?
There ended up being a battery call.
And, sir, were you the lead officer on this case?
Yes.
Were there any other backup officers there with you?
I believe so.
Sir, on that date, August the 28th of 2019, did you come in contact with Sarah Boone?
Yes.
Sir, on that date, did you observe any injuries on Sarah Boone?
I observed redness on the left side of her neck and what to be an old injury to her right eye.
Sir, on August 28th of 2019, did you come in contact with Jorge Torres?
Yes.
And did you notice any injuries on Mr. Torres?
Yes. He had some redness on it by his left eye.
Sir, on that day, was Mr. Torres placed under arrest?
Yes.
Thank you. I have no further questions.
Any cross-examination?
Yes. Is it fair to say that Mr. Torres had quite a few marks on him?
From my report, I remember marking the left by redness by his left eye.
And did you have the body worn camera activated when you responded to this call?
I believe so.
Right. And so that would be the best evidence of those video and audio as to what occurred while you were on scene.
It would, especially since this happened 4 years or 5 years ago now.
And did Mr. Torres refuse to say what happened that day?
He did.
Based on the conclusion of your investigation, which involved talking to Boone and attempting to talk to Mr. Torres, as well as your visual observations of both them and the scene, is that how you all reach your conclusions?
Yes.
No other questions?
Any redirect?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Mr. Kay?
Yes, sir.
Thank you, sir.
Thank you.
Defense, you can call your next witness.
Judge, may we approach him?
Yes.
Okay, so that went really quick. Looks like defense is unprepared again to move forward with another witness. You know, I realize I'm such a pain in the butt about these guys, but this annoys me. Like, I realize, like, they're coming on late and all of that, but there's 3 of them plus 2 paralegals. You know, Henderson yesterday wanting to talk about property, but doesn't have the property list for the detective, doesn't know where it is. Come on. You know what you're going to talk about. You know what you're going to ask. Dot your I's, cross your T's, and be ready.
Defense, you can call your next witness.
This is annoying.
Judge, at this time, the defense calls Deputy Koepsell or Detective, excuse me.
Another deputy. Okay, I'm curious as to why the state asked about the body cam, but they're not entering the body cam into evidence. Like, or they're going to do it on rebuttal. But they dismissed the deputy. Yeah, it's some word, isn't it tomorrow, kiddo? Rebuttal. It's a great word.
Please swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good morning again. Could you state your full name and date of birth for the record? Or, I'm sorry, full name and spell it for us.
It's Chelsey Koepsell, Chelsey. Last name is Koepsell.
All right, thank you. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
In relation to this case, on February the 26th of 2020, did you have the occasion to interview Abraham Marino?
Yes, it did.
Was that interview recorded, ma'am?
Yes, it was.
Do you remember as part of that interview that Mr. Marino tell you that he had contact with Sarah Boone on February the 24th of 2020?
Are you asking the night of the incident when police were called out?
Yes, the next morning,
The day that we were called.
that you were called out.
Okay.
The 24th.
So yes, he did have contact with her, but it wasn't in the morning. It was while we were there.
While you were there?
Yes.
Okay. What time did you get there? That's probably what's wrong.
I got there around 14:20 hours, which would be 2:20 in the afternoon.
Okay. So the afternoon on the 24th.
No, it was later. I recall, I believe I was doing paperwork in my vehicle. So it would have been at some point during the investigation, but it wasn't, I didn't notice him until, I'm not sure if I noticed him until before or after Sarah was interviewed.
All right. But to his interview part, the interview, did he tell you in the interview that he had contact with Miss Boone on that day?
Yes, he did.
Did he tell you at that time that Miss Boone had made a statement to him?
Yes, he did.
Do you remember what that statement was?
I don't wish to quote what he stated. So I don't know the exact verbiage, but he basically replayed what, I'm not sure if he replayed what exactly occurred that day, but I do know he mentioned something about, she mentioned being dragged down the stairs a couple days prior.
Did he say to you during that interview that Sarah Boone told us that a couple of days ago they had gotten into a fight where he grabbed her by her hair and dragged her down the steps?
I would assume that he's reading my report, and that does sound similar to what my report should say.
So this statement was given on the 27th of February. I'm sorry, the 26th of February.
She's hard
You
to
agree with that?
Yes, I was.
She's been here before.
The contact and the statement that Ms. Boone made to Mr. Moreno was on the 24th of February. Is that correct?
Repeat the question, I'm sorry.
When Mr. Moreno is saying that Ms. Boone came up to him and made this statement that we just talked about,
Yes,
that was on February the 24th. Is that correct?
that is correct.
So when she said a couple of days ago, that would have brought it back to February the 22nd. Is that correct?
Potentially, yes.
Ma'am, during that interview with you, did Mr. Moreno ever indicate to you that when he had contact with Miss Boone on the 24th, that Sarah Boone told him what happened was an accident. Did he say that Sarah Boone stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
I don't recall the entirety of that being accurate. Yeah, I don't recall the entirety of what he just said being accurate.
Do you remember him saying that at all?
He did say that she had, I believe he said on the recording, passed out. So that's why, like, part of the statements might be accurate, but.
Okay. Ma'am, would it refresh your memory if you were to see the recorded statement?
His recorded statement,
Yes.
transcription?
Yes.
Sure, yeah, great.
May I approach the witness?
You may.
Now take your time. Wait for that.
Okay,
When you are ready, just let me know.
okay. I don't recall all the statements that you asked or the way you asked it, but
Would it help if I repeat it?
sure, yeah.
Okay.
You asked, like, you said multiple statements,
Yes,
so
ma'am.
this was a like 11-minute interview.
All right. The statement would be that Sarah Boone stated to Mr. Marino that she was teaching him a lesson and things got out of hand and that she fell asleep. And I'm wanting to know.
Did you say, okay, I thought I heard you say passed out the first time. I'm not sure if you said passed out or fell asleep.
Fell asleep.
Fell asleep, okay.
And what I'm asking is there any indication that he told you that statement on the date of that interview on the 26th?
Sorry, I'm trying to go to the part where we talked about that.
Yes, ma'am, take your time.
Okay. Okay, so like I had stated, there were certain things that I thought was accurate from your statement. He stated, I don't really, do I just read exactly what it says? Do you need like the number next to it or anything?
Yes, I have no problem with you reading what he said.
Okay, then she,
Approach.
Okay, see, he's trying to impeach her that they didn't do something, but I don't think he's like, she seems to believe that he is not reading it.
Ma'am, you cannot read the statement at this time.
okay.
Thank you.
Okay.
You may continue, Mr. Henderson.
He described,
Hang on.
No.
Just wait for a
Oh,
question,
so
okay?
sorry.
It's okay.
yes, sorry.
Ma'am, and anywhere in that interview, do you see reference to this statement that Sarah stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
No to the two parts, the first two parts of your question. I heard passed out the first time you asked me this question, and that's why I said that part of it was accurate, because he did say that she passed out in his statement. That was what Sarah told him.
Okay, did she say she was teaching him a lesson? Is that in there?
No,
And things got out of hand. Is that in there?
no, I don't recall that.
May I approach the witness?
Yes.
And again, ma'am, this interview was on February the 26th of 2020. Is that correct?
Yes, it was.
Thank you. I have no further questions.
Okay, so because
Any cross-examination?
Sarah is saying that that's what he said. Okay, I don't know. In his testimony before, he did say that he talked to Sarah, but it's not in her report because maybe
All right,
he
thank you.
didn't
Can this
say
witness be released?
anything to her.
Yes, Your
Not a
Honor.
big deal.
State?
Yes, Your Honor.
All right, thank you.
That was the worst impeachment I've ever seen. Like, what was that? Do you guys feel that they impeached her or made her look not credible at all? I don't know. Maybe I'm just too annoyed with them at this point to be reasonable.
Defense? Call the next witness.
I believe Dr. Brandon is here. Madam Judge.
All right.
Making sure.
Oh, we're going to get an expert witness. We got a forensic psychologist coming up. They have two, by the way.
Judge Mayweather.
Yes, sir.
Okay. We're going to have a lot of sidebar today. Oh, can you imagine if Dr. Curry was here? Somebody mentioned that previously. Like, can you imagine if Dr. Curry got to actually do some work with Sarah Boone? I mean, she had so much fun with Amber Heard. Oh man. That would be a Hallmark movie. Or a Lifetime movie. Maybe Dark Mark, like we said yesterday. Tomorrow, kiddo, I'm glad my avatar is amusing you because even when I'm muted, like the eyes keep going anyway and blinking and just like, can't believe what's going on. She's passing notes to the audience. No, those are the paralegals behind her. She is allowed to do that. Yeah. Can the sidebar come with Jello? I guess if you like. Yes, it could. Oh, wow. The sound just went even weirder. It just went dead. You guys can still hear me though, right? Because the white noise that Judge Kraynick usually plays just disappeared. I want my juice box. Give me my Pop-Tarts. Exactly tomorrow, kiddo. Yeah, I'm not a fan of Jello. It's jiggly food. Like, I don't like jiggly food. Yeah. I want to know, like, who invented Jello? I know it's used, like, for other things. Well, Jello is like the box stuff. That's like the desserty thing for kids. Like, it's weird. And it gets served in every hospital in America on the liquids tray. No squid for me. No jiggly food. If it wiggles or it jiggles, I don't want to see it on my plate. No. Wow, this is quiet. And Sarah's just sitting so quietly. Like, this is a long sidebar for an expert witness coming up. And I wonder if he used any of those medical documents that can't come in for his expert opinion. And that could be what they're talking about. Because yesterday I thought that might be a problem when that got tossed. Oh, wow. Where's the cam go? Uh-oh. I better look. Oh, no, there it is. Whoa. Okay, it was them. All right.
Your Honor, at this time, the defense would call Dr. Michael Brandon.
All right, very good.
Oh, we're gonna hear. It sounds like Mr. Kevin Beck is gonna be doing the questioning. To direct on this
Do you
one.
swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Doctor, good morning. Could you state and spell your name for the record for us?
Michael Brandon, Brannon.
All right, thank you. Counselor, you may inquire.
Thank you. Dr. Brandon, good morning.
Good morning.
Ms. Fry, having just traveled from Miami to Orlando.
Yes,
Is that not correct? Okay.
it was a good drive.
Would you please describe for the jury your background, training, and experience, both in forensic psychology as well as battered women syndrome?
Sure. So I'm a psychologist licensed in the state of Florida. I have a bachelor's degree in psychology. That's from a university called Nova University. I also have a master's degree in psychology. I received that in 1980, also in psychology. And I received my doctoral degree in psychology after a year internship where I worked with severely mentally ill individuals in Hialeah, Florida. In 1988, I finished my degree requirements for my doctorate in psychology. And in 1990, I was licensed as a psychologist. I've been operating as a psychologist since then, since 1990. Originally, I started off doing the work that most people kind of think about when they think about psychologists, doing therapy, counseling with people, helping them through with their problems, things like that. In 1994, I began on a career almost quite accidentally as a forensic psychologist when I testified in my first case in front of a jury. And from that time on, I've been doing mostly forensic psychology. My practice very quickly changed from that time on. I'm currently the co-director of the Institute for Behavioral Sciences and the Law. And anywhere between 80 and 90% of all my work now is related to some legal or court-related matter in the ways in which mental health interfaces or impacts or helps to give opinions about various legal issues. I've taught rather extensively in the area of forensic psychology. I teach to mostly legal audiences, but oftentimes too, I speak to groups of psychology students wanting to sit up here and do what I'm doing as well. I'll make long drives and then come up here and talk to people about cases. I also currently on the staff, the adjunct faculty staff for the School of Psychiatry at Florida Atlantic University. I help to train their forensic psychiatrists, so not just psychologists, but psychiatrists in terms of doing this work as a psychologist or as a psychiatrist, a mental health professional who gives opinions in the courtroom.
And are you also required to update your educational background and knowledge as a forensic psychologist?
Yes, sir. So sure. So every 2 years, we're required to get 40 continuing education credits to maintain our license. And part of that is we have to, on a regular basis, update our work in domestic violence or battered women syndrome. So we have to take those courses. We're all required, whether you're a forensic psychologist or not, to take that coursework. So as part of our requirements, we also have to take separate coursework in regards to domestic violence as a general term, or intimate partner violence. But along with that comes discussion as well of battered spouse, or what's oftentimes called battered person syndrome now.
And I apologize. I'm kind of bouncing around here, Doctor. I apologize again. For the uninitiated, just exactly what do you mean by forensic psychology?
So forensic psychology is a division of psychology. Most people don't think about that as often when they think about psychologists. But forensic psychologists are individuals who have degrees in psychology who are working to help to answer questions that come up in the legal system. It could be in criminal cases like we're here for today, answering various criminal questions, giving opinions about those questions. Or it could be in other settings like family settings, divorce proceedings, or sometimes civil settings like personal injury. Someone's claiming some emotional damage or something has happened to them. So forensic psychology is really the way that we use the science of psychology to help give opinions about various legal matters.
Now, what is the DSM or the DSM-5?
So the DSM it stands for Diagnostic and Statistical Manual. It's kind of our code book, if you will, to help us to know what the different symptoms are for different mental health disorders, whether it's major depression or schizophrenia or anxiety. So it gives us a code book of here's the criteria you have to meet in order to have that diagnosis. And then we're able to utilize that in terms of either treatment, even insurance billing, but being able to inform patients too about what condition we think that they're suffering from. It's been updated many times over the years. It started just DSM, and now it's at the Diagnostic and Statistical Manual 5th edition, text revised. So we've gone through a lot of revisions over the years to try to fine tune in an empirical or scientific way what the elements are, if you will, of various mental health conditions.
Now, you've been asked to testify today in regards to battered women's syndrome. Is the battered women's syndrome identified or located within the DSM-5?
So it is not. It is not a diagnostic category in the DSM-5 or other coding books as well. There's others besides the DSM. That's just the most popular one. But it's not a formal diagnosis that it is contained within that book, that classification manual that I just told you about.
Within your field of forensic psychology, however, is there a subcategory that is located within the DSM-5 that experts would recognize as a DSM diagnosis?
Yes, sir.
And what is that, sir?
So that category would be in the trauma section of the DSM-5 TR. There's a whole category on trauma disorders, and it's most closely related to something that we call post-traumatic stress disorder. That isn't the only trauma disorder, but that's the one that what used to be called battered women's syndrome. Now I refer to it as battered person syndrome, but all of it really is more connected to a trauma disorder like post-traumatic stress disorder.
Now, you testify on criminal matters. Do you also testify? You indicated also on personal injury cases and emotional. That would be civil, correct?
Yes, sir.
Okay. In your experience, you've testified as an expert, as a forensic psychologist. You testified for, and today you're testifying for the defense, or were called by the defense. Do you also testify for the state of Florida or other states within this country?
Yes to both of those. I've testified in other states. I also testify for both prosecution, the state or government, depending if it's federal or if it's a state case, and also for the defense. So I really get appointments and hired by both sides.
About how many times have you testified?
Wow. At last count, it was about 1,500 times. It's over that, way over that now. That was from a few years ago. I testify in a lot of different kinds of hearings and trials over the course of, mostly in Florida, but in other states as well.
Now, you're familiar with the fact that there is a special jury instruction that's been recognized by the Florida Supreme Court.
Approach.
Already. Here we go. This is going to be interesting. I mean, he seemed very well qualified. You know. You ready for your morning nap, Shield? Have a good one. He does. Jin, do you think it's the pompous attitude? I don't know. I'm grouchy this morning. Like, I'm looking at everything with side eyes.
The objection is sustained.
State objected, state won. Okay.
I apologize. Doctor, you testified as to battered women's syndrome, battered person syndrome.
We did,
Are there
Beck.
other synonyms or similar names for what you're describing, in particular battered spouse syndrome?
Well, we talk about it in terms of trauma disorders like post-traumatic stress disorder, but the way when it's applied to the legal system is called battered wife, or that was the original terminology for it, battered wife syndrome or battered person syndrome. So really depends on your setting. So in this setting, we oftentimes talk about this particular condition that I've been asked to talk about today, is really referred to as battered spouse syndrome.
And have you been asked to give your opinion as a legal expert and on battered spouse syndrome?
Yes, sir.
How frequently have you been asked to do that?
I've been involved in about 100 cases of just that alone. I've been involved in some sort of testimony about 50 times.
And indicated that you testified for the state, you testified for the defense, you testified in state cases, federal cases. Could you break down on a percentage basis the number of times you testified for the state versus testifying for the defense?
It's really close in terms of the last time we looked at it, it was about 50-50. On most cases, like for instance, if there's a case that involves battered spouse, potentially battered spouse or battered wife syndrome, I'm usually called by the defense first because they raise the issue. If you're called by the prosecution, whether it be federal or state, what oftentimes happens is it's in response to a defense expert that's been called. So do I agree or disagree with that other expert? So I'm usually, the call usually comes first from the defense, but in terms of who I'm hired by, it's pretty even. It's about 50-50.
Now, this time, Your Honor, I will proffer the witness as an expert in the field of forensic psychology.
Yes, approach.
Here we go. Okay. Could it be that they don't want you to use the word expert with BSS because it's not in the DSM and there's no expert status? Like, you don't want to mislead the jury here. This is
Objection is sustained. Wait.
Oh, they're going to have to be careful here. You can't declare yourself an expert in something that can't be categorized. Yes, it is in the law books, and yes, it is part of the defense, and they can talk about it generally, but that word expert.
Objection is still sustained. Mr. Beck, you may continue.
Mr. Beck's not going to be happy about this. Reshuffling.
Has battered spouse syndrome been accepted, to your knowledge, in the Florida court system?
Yes, sir.
Objection, legal conclusion?
Sustained.
Legal conclusion not allowed. Not a legal
The
expert.
classic system or systemology wherein an individual might necessarily suffer and then exhibit symptoms of battered women syndrome.
Yes. So battered spouse syndrome is a woman, usually a woman's response. Doesn't have to be, but that's a classic historical research went into how women respond in situations in which there's intimate partner violence when they've been the victim of violence. Now we know, of course, in other kinds of relationships, men can be a victim of it as well, or whether it's a heterosexual or homosexual relationship, that both men and women can be victims. But we still know the majority of those individuals that are diagnosed with that condition or given that condition, classified with that condition, are women.
Bless you.
We do know that it's a reaction, a strategy that's developed by the person who's being abused to someone who's abusing them in an intimate partner situation. And essentially what they're doing is they've made a determination that they can't effectively escape from the abuse. They can't just leave for some reason. They feel in danger or they've been threatened if they leave that something bad will happen to them. So it's a cognitive or thinking strategy on the part of the person being abused that I have to develop some coping skills or ways of protecting myself or maybe even loved ones as well from some form of imminent violence or danger or lethality. Something bad will happen to me if I don't develop a way of handling this abuse, this constant abuse that's coming towards me. So the battered wife syndrome is really a way of thinking. It's a psychological change that happens with a victim in terms of the way they cope and strategize to stay safe for themselves and other loved ones as well, oftentimes.
I'm going to ask a really silly question, if I may, doctor. I don't know if you've noticed a bruise across the bridge of my nose this morning.
I did see that when I come in. Yes, sir.
Okay. This weekend, okay. Hypothetically, if an individual was digging around in the garbage, the lid fell down and cut his nose, the bridge of his nose wide open, would you as a forensic psychologist anticipate, or a psychologist in general, anticipate that there might be a physical or a psychological reaction or response to that degree of trauma?
So I don't know if it would be trauma or not. It could be, depending on the degree of the injury and the pain and things like that. But certainly you'd view that garbage can differently as you approached it. So it changes your psychology or the way that you look at that particular situation or that particular object. So by viewing it differently, you may engage in different behaviors. You may approach it differently. You may have somebody else approach it. You may approach it with both hands up. So it changes your behavior and your thinking about that garbage can.
Does that also apply to interpersonal relationships?
So it certainly can. No two people always react the same way to every situation. Trauma, one person's trauma is not a trauma to another person. But for people who do develop battered spouse syndrome, they do begin to change the way they view the person who's abusing them and what they have to do in order to maintain either their life or their safety, their physical safety in terms of their behavior and interactions with that person.
Now, is there a specific set of criteria that a psychologist, forensic psychologist, would necessarily rely upon in attempting to make a diagnosis or an assessment of battered women's syndrome?
Yes, sir.
And what are those criteria?
Well, you'd want to see one if some type of abuse has occurred. That abuse can be physical, it can be sexual, it can be emotional, or it can just be the threat of abuse or bad things that's going to happen to you. So there has to be something bad that's happened or that's threatened to be happening over a period of time. So abuse has to be present in order for this to be underway. Without abuse, there's no battered wife syndrome. But that's not enough. There also has to be what's called coercive control. Coercive control is really keeping the person's social interactions, overseen on a regular basis, controlling money, controlling preferences, even TV preferences, sometimes social media, looking at social media that the person is accessing or looking at, who they're talking to on Facebook, who they're texting. So it's a combination of abuse and coercive control that results in a person feeling victimized, but that's still not enough. That person then has to feel like they can't escape from that. They've either been told, if you leave me, you're going to die, or a family member is going to be harmed, your children, your mother, whatever it might be. And as a result of that, they develop strategies to cope with that, acquiescing, pleasing, doing anything they're asked to do, demeaning themselves, allowing themselves to be controlled. All of the things that would fend off, if you will, some abuse or attack or threat to them or someone who surrounds them. So those would be the components that you would need to have, and that dance continues to go on usually repeatedly throughout the course of that relationship.
So I think what you're describing is, in a sense, a subjective nature to the syndrome that's being described.
It's both objective and subjective. So objective in terms of the facts, like what's really happening. A person's being abused, they're being told certain things, there's control over them. But then a subjective part is the person's interpretation of that, their perception of that. So there's really both going on, and they have to kind of work together in order for this syndrome to be formalized and properly diagnosed.
You indicated that there's sometimes maybe some defense mechanisms that are, or strategies that are devised by the battered individual, the abused individual.
Yes, sir.
In your experience and your training, do controlled substances, alcohol, drugs frequently appear in your analysis or assessment?
Yes. And the way they appear is they can appear either from the abuser or the abused or both. What can happen from the abuser standpoint is they may only be abusive, or the abuse may become worse if they abuse substances. From the abused standpoint, it may be self-medication. It may be a way of coping with the anxiety that there's going to be something bad that potentially could happen to them or somebody else. It's kind of a way of dealing with walking on the eggshells. So if I use substances, that can deaden the pain, if you will, for me, or help me to forget about it. So it's oftentimes, not always, but oftentimes part of either the abuser's behavior or the abused behavior.
Do they, in your experience, do they on occasion actually defend the individual that is abusing them?
That's a very frequent part of this syndrome. Not always, but it's very frequent. It's why interviewing them becomes difficult sometimes, because they're used to explaining away their behavior, the abuser's behavior, my black eye, my missing tooth, his screaming and yelling in the background while I'm talking to mom on the phone. So they're used to making excuses for it. It's part of the coping strategy, trying to explain away this behavior. He's had a bad day. She's, really upset about something else that's going on. She's really never like this at any other time. So defending that person is oftentimes a part of the battered spouse syndrome, and getting the person who's been abused to get them to stop defending them so they can talk about the actual abuse becomes a challenge.
Now, the DSM makes reference on occasion to rule outs, I assume for the diagnosis that's being applied. What is a rule out?
A rule out in our parlance says that we should consider these things before we look at other diagnoses. So, for instance, if we're going to consider schizophrenia, we should rule out substance abuse first, because oftentimes some drugs can create hallucinations and delusions and psychotic symptoms. So there's always rule outs, just like there are for medical conditions. So look for this before you consider this, is really what a rule out is.
Are there specific rule outs for battered women syndrome or PTSD?
Sure. So there's rule outs for everything, because you're considering a number of different conditions before you make a differential diagnosis, or you pick that's the one that I think best fits this person. So yes, there's rule outs for both of those.
For my sake, what is a differential diagnosis?
That's how you decide which one. It's whether it's your medical doctor, your psychologist, whoever. It's how they pick the right diagnosis. So you're going through kind of a card catalog in your head, and you're saying, all right, there's symptoms of this, but that's also consistent with symptoms of that. So is it schizophrenia? Is it bipolar disorder? Now I have to ask more questions. It's a decision tree. And that decision tree helps you to inform the person and either make a diagnosis in a legal setting or help to treat them clinically.
Now, if the individual, the psychologist who's doing the evaluation, identifies the presence of certain rule outs, what is their response professionally to those rule outs in establishing or assessing the patient?
You have to go down a decision tree. And we all kind of do decision trees in our mind every day about what we should do or shouldn't do in certain situations. It happens automatically. It's more structured when you're doing it professionally. So if you have a concern about substances, then you would kind of take that track and you'd have to ask a lot of questions in that area. So you'd want to know what kind of substances, how often are they using those substances, what kind of effect have those substances had on them before. I just picked one of many possible rule outs there. But every one of them you'd have to explore or ask additional questions, because of course you want to come up with the wrong diagnosis, because in a legal setting that leads you to a bad opinion. In a clinical setting, it leads to bad treatment.
Now, I want to go back just a second. We talked about the subjective nature of the abused individual's understanding of what's happening. Does this subjective, or does the experience that they have suffered result in, on occasion, their experiencing or their anticipating or assuming or imagining a threat that others may not?
Yes, sir.
Yes.
It's interesting. On Twitter, they are stating that juror number 13 is not taking their eyes off Sarah Boone during testimony, during this Dr. Bannon's testimony. Sarah herself is taking lots of notes, so are several members of the jury. Now, I posted you a link to a good article from Health in regards to BSS in kind of like layperson's language. It's very good. Sarah seems to be upbeat today. I think Rocket Couch was spot on about, like, Sarah did what she wanted to do. She wanted to be heard. All along, she just wanted someone to hear her side of it. She didn't feel that the detectives had considered her side of it at all. She feels wronged in being labeled as an aggressor. And so I don't blame her for being a little upbeat. But the friend that she met in prison, her bunkmate, has been in the galley every day. I do believe that's who she was perhaps giving the eyes we thought were to the cameraman.
Doctor, from what you described this morning, I think we're talking about a complex and sophisticated process for assessing and diagnosing PTSD, battered women, the matters that you described. Is that a fair statement?
Yes, sir.
And in this instance, this particular matter regarding the state versus Sarah Boone, were you approached about the possibility of doing an assessment as to Sarah Boone?
Approach.
There's a lot of objections going on this morning. Did anyone hear what he said? I'm having difficulty hearing the prosecution when they make their objections. I don't know what that was on. Did anybody hear the type of objection they made? This is a long one too. Yeah, I couldn't catch it tomorrow, kiddo. Thank you for going back. Unfortunately, I can't do that with the live going. I wonder if this statement from Twitter will fit. Relevance. Okay, thank you, tomorrow, kiddo. This is from Twitter that I just posted. That was somebody's comment. Like, people are like lit up with this testimony here for Dr. Brennan. They're like,
Objection sustained.
and they sustained it for relevance. They're not going to let them go into areas that are. They're not going to let them get the jury all up in it. By the way, guys, if you see the hashtag Sarah Boone in the comment, that means I'm pulling it from Twitter. Like, it saves me extra typing, just so you know.
Doctor, when you are retained to do an evaluation in these matters, what is your practice in regards to the assessment proceedings, the assessment efforts?
Well, I'd first want to know what type of an assessment that it is, because there's different methods of approach that you'd use to analyze and be able to give an opinion on whatever question's being asked of you. So the very first goal for me as a forensic psychologist is to isolate what the question is. So what are they asking me to do? Because I want to know, A, can I do that? Am I qualified to do that, or should I refer that to somebody else? Or B, is that something I'm going to have enough time to do and enough resources to do? Then the next thing I would do is start asking questions about specifically what you already have or what can you get to help me answer this question. So right away, I'd start to find out what's available. As forensic psychologists, we're supposed to do comprehensive evaluations of whatever the legal issue or question is, and it's supposed to rely on multiple sources of information. So depending again upon the question, I'm trying to then define early on what are those multiple pieces of information I'm going to need to help to try to give an opinion and a educated opinion about that matter.
Have you done an assessment in this particular case?
No, sir.
Can you tell us very briefly whether that was your decision?
Objection, relevance.
Okay, that's fine. That's fine. Move on.
Objection sustained.
In your experience, doctor,
Thank you very much.
can battered women's syndrome rear its ugly head? For instance, when there are threats to other members of the family, two-legged or four?
So yes, that's very common, that it's not just the person. It increases the terror from someone who's doing the abuse to mention other family members that they might also suffer abuse. So whether it's emotional or physical, those type of things are very common. Not always, but it's very common in the course of domestic violence cases or intimate partner violence cases.
And that fear that's developed by the abused individual may exist contemporaneously with other issues, alcoholism, schizophrenia, and the like. Is that correct?
Yes, sir. They can all be combined together. And certainly that increases if there's other family members that are threatened or live in the same home or close by. That can increase the terror. The purpose of that is to increase control, to make sure the abuser has more control over the person who's being abused.
1 second, Your Honor. May I?
Yes, sir.
So, in doing an assessment, doctor, do you look at outside materials?
Yes, sir, always.
And what kind of outside materials do you necessarily review in order to make this assessment?
Specifically to battered woman syndrome?
Yes, sir. Yes, sir.
So specific to this, you'd want to look at a lot of different sources of information because you're trying to, make a diagnosis if there's a trauma-related disorder, but you're also trying to figure out if there's the other elements necessary to make the diagnosis as well, like abuse that's been chronic over a period of time, and that the person feels they can't leave that situation, and if other people have been threatened. So you'd want to know things like not only what the facts are of the particular incident, usually some crime that's been committed, but you'd want to know the history of those behaviors. Has anyone else seen those? Or there are people you can talk to, friends, neighbors, bosses, anybody who's seen or heard of this abuse before. Have there been medical visits where the person has actually been damaged and shown up, made some other excuse, they slipped or fell or whatever it might be? You'd want to do psychological testing as a forensic psychologist because we have very good tests that help us to determine whether someone's suffering from a trauma-based disorder or not. You'd want to know if the person who'd been accused of the crime for this type of evaluation made any statements to the police. If they did, you'd want to hear that statement. Or has there been a 911 call? Or calls. If that's happened, you'd want to hear that too. So any evidence you could collect, and these are some of those questions I was talking to you about before, you'd want to ask the person who's trying to hire you in the beginning, well, tell me what you have, because you'd want to see whether or not you're going to be able to make this analysis or not. So it's not good enough just to talk to the person, because that's just one form of information. It's almost like being a behavioral detective, if you will, as a forensic psychologist, because we're trying to get as much evidence wrapping around our interview with the person as possible to be able to guide our questions, but inform us and see whether there's what we call convergent validity. It's a fancy way of saying, does everything agree with each other? Does everything connect in a way that it all sort of makes sense? Or are these strange conflicting pieces of evidence that we need to explain away, or it just doesn't fit the criteria? So it's a rather comprehensive and complex evaluation has to be conducted to come up with this. And the final piece I'd say about it is that because oftentimes the abused person is defending still the person that they've oftentimes committed a crime against, it takes a bit of time to get to where you need to go. With all victims of trauma, whether you're talking about situations where you're doing therapy or you're doing an analysis in this type of setting, a criminal setting, it usually takes some time to break through that and get them to trust you to talk about the trauma, but to stop defending the person and talk about the abuse and how they felt about the abuse. Your goal, if you will, is to be able to see what's happening in that situation through the abused person's eyes. If you look at it through your eyes, often it doesn't seem to make sense. But if you look at it through their eyes, if it meets the criteria for battered spouse, then you can better understand their world and what they're dealing with.
And real briefly, some of the things that you are evaluating when you examine, particularly the individual themselves, you're looking for anxiety and or fear.
Yes.
Low self-esteem.
Yes.
Are you looking for depression?
Yes.
Are you looking for any form of social or interpersonal withdrawal?
Withdrawal, especially if it's forced withdrawal, controlled withdrawal, if there's consequences to socializing with my family, my friends, calling them on the phone, texting them. So especially in that context.
Stockholm Syndrome.
Sure, that can be part of it.
And what is Stockholm Syndrome, real briefly?
So it's really adapting to someone who's captive or taking over a person, controlling their life, sort of adapting to that situation. The famous model of that would be many, many decades ago, a woman called Patty Hearst, who was kidnapped. But it's taking on the beliefs and taking on an acceptance, if you will, of a kind of a captive situation. And in these situations with women who have been abused, who meet the criteria for battered spouse syndrome, they oftentimes adapt, defend, and take on in an acquiescent way that this is okay and I'm part of this situation as opposed to opposed to the situation.
Will this syndrome exhibit itself in physical attributes?
It can, at times, even physical illness at times.
Inability to sleep, inability to keep food down, and those type of things.
Sure. Yes, sir.
Would that individual potentially experience hypervigilance?
Well, that's a large part of it, of any trauma-based disorder, is hypervigilance. What changes when you've been traumatized, any kind of trauma, not just abuse, but what changes is your perception of danger. So whether it's the lid of the garbage can hitting on your nose, or whether it's someone being abusive towards you, those situations change your perception of danger. So you no longer see that object or that person in the same way. You have a foreboding sense of danger could occur. So other people may not perceive it with that person. He's so nice at work, or he's nice in these other settings, or he's so great on the softball field, but at home he's different. So that person who's being abused, their perception changes.
Does that include denial?
It could include denial, and oftentimes that's part of the explanation. The defensiveness of that person is the denial of how bad things are that are going on.
Thank you, Doctor. For this time.
Any cross-examination?
Yes, sir. Good morning, doctor.
Good morning.
Nice to see you in person.
Good to see you again.
So there's a subjective component to trauma, is what I understand you're saying, correct?
Always. Yes, sir.
And so hypothetically, a couple could be in a 3.5-year relationship with physical violence, emotional violence, even sexual violence, but either or both of those partners may or may not believe that is a traumatic experience for him or herself, correct?
Yes, sir. People mistake the stim happens as the trauma. The trauma is really the reaction to it. So bad things that happen, people don't always react in the same way to them. So yes, sir, that's correct.
So for instance, a homicide detective or a homicide prosecutor may go out to a scene and see a freshly dead body, and their perception of that environmental stimulus may be very different from somebody who works at Dunkin' Donuts and just gives us muffins in the morning coming across a dead body. Is that fair?
Yes, sir. That homicide detective may be able to go eat lunch right after it, and the other person who works at the donut restaurant may not be able to eat for a couple of days as a result. So yes, perception is a big part of how trauma occurs.
And I understand your answers today, and I'm not saying that they were different the other day, but I understand you to say that it's very important to do a comprehensive evaluation to get the full picture of what is going on in the perceived battered spouse mind. Correct?
When we approach.
Yes.
Oh, I'm kind of liking this morning's Mr. J. William J. Will J. ADA. Is he inferring that, dude, are you going by your experience and you only met the woman once? Like, what? Yeah, okay, that was a bit snarky on my behalf, but I think you know where I'm going. I think you know what I'm saying. Well, oh, in regards to your question, Charlie Hobo, tomorrow Kid always right in regards to covert narcissism. in other narcissisms, but there is actually a type of narcissism that does have low self-esteem, and it's where it comes from. It's very focused on the self. Remember, the definition of narcissism is the inward looking. Yes, it is. Tomorrow Kiddo was actually correct in how she says that, the inward looking and them not wanting to be hyper focusing on what they do. It creates I want to say paranoia, but it's not actually. But actually the comments that she made are accurate in regards to other types of narcissism. There can be some slight low self-esteem, not wanting people to focus on certain things and everything, making them, retreat. But there's actually
The
a
objection is overruled.
specific type. Ooh, wait, the defense just lost the objection?
We've been talking about the
Ouch.
importance of doing
They're
a
not batting
comprehensive
100 today.
evaluation with as many collateral sources as one could possibly have when making an assessment about the battered spouse syndrome, correct?
Yes, sir. Relevant piece of information. Yes, sir.
And would you agree that obviously the person who is accused of committing a crime, there are credibility issues that you do need to care for when relying upon that person's history provided about the events leading to that and the past events describing the relationship with the intimate partner?
Yes, sir. In every forensic evaluation, that's the case.
Is this particularly important if there's a comorbidity with an alcohol abuse disorder?
Yes.
And can you tell the jury what alcohol abuse disorder means in the DSM-5 TR?
Sure. It's the biggest part of it is it's not just the use of alcohol, it's impairment that happens as a result. So it's the excessive use of alcohol, but that could mean something different, just like the excessive use of marijuana might mean. But it's the use of alcohol to the degree that it impairs or affects a person's life. And with that may come a lot of other things like deceitfulness or aggression or unreliability, sleep or somatic problems, difficulties. So, but the important thing to remember there is that it's the use of a substance that impairs or affects a person's life.
And if there is alcohol involved in the histories being given about either the event in question or any preceding events, must the evaluator take that into account when evaluating the memories and perceptions of the person giving them that history?
Yes. So in introducing that new topic about memory, we know that substances can interfere and impair memory. So as a result of that, you'd want to know what they were using, how close it was. If you're talking about a particular event, like a crime, you'd want to know if there was substance usage, and if so, what the person's memory functioning was, and does that match up with other sources of information about what those events were.
Are you familiar with the narcissistic personality disorder?
Yes, sir, of course.
Is that something recognized in the DSM-5 TR?
Yes, sir.
And can you tell us whether or not a person who is giving a history, whether it's the patient/client or whatnot, has traits, perhaps not a diagnosis, but even just traits of the narcissistic personality disorder? Is that something the evaluator should account for in evaluating the credibility of the history given?
Yes.
And why is that?
Well, because all forms of disorders or conditions or just traits may lead to inaccurate information, either not purposely or purposely. They may be deceptive. So certain personality disorders or traits can lead to deception or inappropriate or inaccurate information. That's why you need more than one source of information. Does what this person's saying to me check out with other sources of information?
And I don't mean to quiz you on it, but can you tell us some of the criteria for the narcissistic personality disorder?
I can, yes, sir. So it is a grandiose sense of self-worth. It's the consideration of yourself over anybody else. It's kind of operating in your own world. So it's an inflated sense of who you are. It's a misperception of how important you are to other people and your meaning to other people. It's a sense of specialness, that you stand out from other people in terms of special skill or skills, and that other people, if they don't recognize that, they should recognize that. So the biggest heading there is an inflated sense of self-esteem and grandiosity.
Are you familiar with an adjustment disorder diagnosis?
Yes, sir.
And is that in the DSM-5 TR?
Yes, sir. Correct.
Can you tell us about that?
Adjustment disorder is a person's reaction, and it could be emotional, it can be behavioral, or it can be both, to a situation that occurs. You broke up with your boyfriend or girlfriend. So you're upset about that. And so as a result, you're tearful, you're anxious or nervous or worried about what may happen to you as a result of breaking up with them. Or you behaviorally may not start not going to work, or get into more arguments or fights with your children as a result. So it's a temporary reaction to a stressful situation that occurs in some individuals.
And hypothetically, if a person who is giving a history for criteria of diagnosis, let me strike that. If somebody is giving a history and that is being used to come to an evaluation conclusion of battered spouse syndrome, if that person has been diagnosed with adjustment disorder predating the traumatic relationship, is that something the evaluator should take into account?
You'd want to know any prior diagnosis, because it may not necessarily be exclusionary, but it could. So adjustment disorder is a temporary reaction. You're upset, it's a temporary, and most of them just go away on their own. Whereas something else like a traumatic stress disorder is long-term. It's something that person's stuck with for a period of time that usually doesn't just go away on its own. So yes, you'd want to know that for that term I used before, that differential diagnosis. You'd want to know those things to compare and contrast them and hold them up against each other.
Now, hypothetically, if somebody says things like, I'm the best thing that has ever happened to you, and I'm the best you'll ever do, are those indications of the narcissistic personality disorder?
Well, they could be. You wouldn't want just that alone. You'd want to see if that was happening in other settings. Is that happening on the job, with friends, with family members? Is it showing up on psychological testing? But certainly that would be a red flag. You'd go, I want to pay more attention to that. I want to investigate that further.
And is it important when evaluating trauma-based disorders, because they're based on emotional reactions, to do that rule out on alcohol or drug use?
Certainly you'd want to do that. It's not usually disguised as a trauma-based disorder. Alcohol and trauma aren't usually rule outs for each other, but it could exacerbate a condition. It could make you diagnose a trauma condition when it's just an adjustment disorder. I say just, I don't mean to minimize it, but it's not as serious as a trauma-based disorder.
Is it important to consider whether the abuser and or the abused behave differently in the absence of alcohol or drugs?
Yes.
And why is that?
Well, because you're trying to analyze a psychological condition. If as a result of drug or alcohol abuse, their behavior changes or their perceptions change, that's not a psychological condition, that's a substance abuse disorder. So that's why you'd want to know that. So if their condition remains the same, maybe it's a little worse when they're using drugs or alcohol, but it's the same perception of threat or danger, then you're going to diagnose a trauma-based disorder. If not, then you're going to diagnose a substance abuse disorder. You can have both, but you'd want to rule one out as opposed to the other.
And are you familiar with the classic three-step cycle of battered spouse syndrome or domestic violence?
Yes, sir, I am.
Can you explain that to the jury?
Sure. So there's a cycle of violence that was first developed by a woman in the 70s called Lenore Walker, Dr. Lenore Walker. She's a psychologist who's usually credited with developing the whole theory of battered spouse syndrome. And in the classic model, which we know oftentimes happens, not every time, but in the classic model, there's a period of tension buildup where things are happening, little arguments are happening, there's bickering back and forth, there may be some threats or some loud voices back and forth, but it's all things that are leading up to a possible violent episode. Then there's the episode that happens itself, the violent episode. It could be verbal, sexual, physical, but there's the violent incident that occurs. And then after that violent episode occurs, there's a honeymoon phase where the person who's done the abuse, they're apologizing, taking that person who was abused out to dinner, buying them things, saying nice things to them, complimenting them to sort of make up for the abuse. And it's kind of it's called the cycle of violence. And the reason why is it tends to repeat itself in a lot of these situations of battered spouse syndrome, where you see this repeating itself over and over and over again. So people are kind of stuck in these revolving doors in their relationship.
And can one cycle be enough to traumatize a person?
Yes.
Does this trauma necessarily have to be coming from a man to a woman?
No.
And in fact, as times have changed, language has changed. And so when we keep referring to it as battered woman syndrome in the courtroom today, what we're actually talking about now is battered spouse syndrome or even intimate partner violence. Yes,
I mean, interpartner violence can happen outside legal settings, but it's really a kind of the large over grouping, if you will, to be able to talk about all of these other things that can happen as a result, like trauma-based disorders and battered spouse syndrome. And you're right. The later research has kind of pulled us away from thinking this only happens to women in heterosexual relationships. We know now there's all sorts of derivations, and that men can suffer also from battered spouse syndrome, battered person syndrome, homosexual couples. So we know it goes around to everybody, but still, women are more often diagnosed with battered spouse syndrome than anybody else.
Does the trauma have to come in the form of physical violence?
No, sir.
Does it have to come in the form of sexual violence?
No, sir.
Can it come in the form of emotional or mental violence?
Yes, sir.
And would examples of that include such as running the partner down and telling them that they're no good and, just general insulting and lowering their value?
It could. Remember, that's the stimulus, so it would depend on how the person who's receiving that responds to it as to whether or not it becomes traumatic. But yes, sir, that would be the first red flag you'd want to investigate.
And you mentioned isolation before. So if somebody in a hypothetical intimate partner setting is trying to isolate the partner from his or her family members or friends or coworkers, can that be, and I'm not saying necessarily, can that be indications of intimate partner violence that could lead to battered spouse syndrome?
So sure, that'd be an example of coercive control. So if a person was doing that, that's consistent with that classification of battered person syndrome. Yes.
And hypothetically, controlling another person, the intimate partner's personal property or effects, such as a birth certificate or identification papers, can that be indication of emotional trauma towards the partner who is lacking the control over those identification papers?
So that's a stimulus that could result, depending on how the person subjectively perceives it, in some trauma. So yes, all of the things that you mentioned could be stimulus, if you will, that a person could perceive as traumatic.
And hypothetically, if one partner A gives partner B a gift, such as a bicycle, but partner A continues to maintain that the bicycle is his or hers because he or she bought it, even though it was a gift of B, can that be a form of emotional abuse towards B?
Sure, it sounds like control, but I guess you could interpret it as emotional abuse too, but it sounds more like a control mechanism that'd be consistent.
I'm not suggesting that it's legally or morally okay, but when one intimate partner does these hypothetical emotional things, non-physical violent things to partner B, if partner B has poor personal skills and coping skills and may be consuming alcohol, is it unreasonable or unfathomable to hear that partner B responded with physical violence to partner A?
Objection, assuming facts not in evidence.
Sustained. Yes.
Wow. I have to say I'm quite impressed with how Mr. ADA Will J has turned all this witness into providing some really good information for the jury tomorrow in regards to narcissism, control issues. Remember though, this expert, although he knows his stuff, never examined Sarah Boone. He only went over the records provided to him by the defense to make his decisions. I do not believe they are using him to actually state that Sarah has BSS. I believe they are using it to educate the jury into regards to what BSS was and how an individual may fit that.
After hearing argument of counsel, the objection is overruled.
So,
Wow, defense lost their second objection.
Please go ahead.
so it would increase the probability of physical violence. So if those things, in fact, were perceived as threatening or abusive in any way or insulting to the person who they were directed towards, it would increase the probability of physical violence.
There we go.
And then again, the perceptions are all in the eye of the beholder, whether emotional things that are said to one another or physical things are done to one another, whether the recipient of that behavior views it as trauma is a subjective decision by that person. Right?
Yes, the perception is the impact. So that's how you would know that it's just, water off a duck's back, or is it something that kind of sticks with me and I think about it all the time?
Now, you mentioned earlier Anxiety, low self-esteem, and depression can all be components of battered spouse syndrome, correct?
Correct.
Is it important as the evaluator to rule out whether or not these conditions predated the violent or abusive relationship?
Yes.
And why is that?
Well, because where things start is important diagnostically. So if all of those things are in place, all of the symptoms that were just mentioned are in place, then you wouldn't attribute those to the abuse. You'd say those things were pre-existing. Now, abuse could make it worse, but in terms of your diagnosis, you'd need to know where things started. So if those symptoms didn't start at the time where there was abuse that was alleged to have occurred, then it's unlikely that it's attributed to that abuse.
And independent of any narcissistic personality disorder traits, would you agree that anybody in a certain legal setting has a motivation to present themselves in a certain way?
Yes, to do impression management, either depending on the outcome. So if there's punitive sanctions, they may lie to make themselves look worse, or as a result, if they're in other settings like divorce settings, they may lie to make themselves look better. So there's always some impression management you have to kind of look through in your evaluation.
And that's important for an evaluator?
It should be looked at in every evaluation.
Thank you.
Yes, sir.
Whoa.
Any redirect examination?
Whoa, I knew he would. This is losing points here.
Just want to, one more time, in response to the state's questioning, you indicated that where an individual's credibility may be in question, there is a necessity that the individual who's making the assessment corroborate whatever they're being told. Is that correct?
Yes, sir. In a number of different ways. We have psychological tests that assess for things called malingering or faking mental health problems or difficulties. So you'd want to do that. You'd want to look at other evidence to see if it's all consistent. So it's very important you don't just rely on self-report.
It's possible that an individual may exhibit one or two attributes of a particular DSM diagnosis, but not actually qualify because it's simply not there.
Right. Sure. So sometimes like social isolation can be because we're introverted, or it could be part of depression. So you need to kind of follow it out and see how many of the symptoms are there to see whether or not it meets the criteria.
So I may exhibit one or two symptoms of narcissism, but not qualify because I don't meet all of those, or a significant number of the indicators that you would rely upon to make that diagnosis.
Yes, sir. Or it can be situationally based, like we may display narcissistic features here in a courtroom, but may not do that in any other part of our life.
Now, in your experience, have you learned either through your studies, experience, and so on, whether or not the abusive behavior may begin based upon an individual's perception of things occurring to him as a child or her as a child? In other words, if they grow up in an abusive household.
Okay, I understand.
Sustained.
You've indicated that there are things that, I think in response to the state's cross-examination, that there are things that may add to or may contribute to a particular psychosis or symptom. Would an individual's background as a child include those type of criteria?
Yes, sir. You're more vulnerable to certain psychological conditions based on your history. So if you've been traumatized before, or bad situations have happened to you before, if you've suffered from depression before, it makes you more vulnerable to those conditions or other conditions later on.
Finally, one question or one symptom that we haven't discussed, I don't think, or maybe it was discussed by the state, was learned helplessness. What is that?
Learned helplessness, I've really spoken about it a little bit, but now we have the fancy term for it. Learned helplessness was really researched by someone named Seligson, a doctor named Seligson, a psychologist, research psychologist. And just real briefly, what it is, it's when someone kind of gives up and feels like there's nothing that they can do to change their situation. It was originally done with laboratory animals, but where a person really feels that no matter what strategy they've taken, like leave, stay, fight, whatever it might be, it won't work. It usually leads to depression or developments of other strategies, like I have to appease or please or make sure I do everything correctly or apologize. So it's really believing that no matter what you do, it won't be effective.
Doctor, thank you for your testimony. Thank you for
Sure.
traveling up here from Miami so early in the morning.
No problem at all.
Thanks for the rest.
Thank you, sir. You can be excused.
Thank you, Your Honor.
Can the parties approach for a moment?
Well, that was quite the interesting testimony. I don't know how the jury is going to perceive whose actual expert witness that was, but I do feel that Mr. J did a really good job of getting some really good information there for the jury to mull on in regards to this could be other things besides BSS. How does Sarah actually get perceived in the category of BSS with all these other things going on? And one thing that this expert actually did say, Dr. Bannon did say, that all other DSMs should be considered prior to. And if BSS is actually something that gets assigned as a component or in addition to. Hey, Anna, thank you so much for the article. I did share it with everybody this morning. Glad to see you. And I agree. Mr. J did an awesome job of getting good information out there. And, you know, so the defense did too. But it didn't actually go and fit Sarah in particular. At least not what I was hearing. I mean, it'll be up to the jury. According to Twitter and those that are in the courtroom posting on there, that the jury was taking notes, okay? And, during the objections in the sidebars, they do a little bit of giggling and stuff. It's getting a little ridiculous. And I lost.
All right, members of the jury, it is 10:40 at this time. We're going to go ahead and take that mid-morning break. Similar instruction I've given you over the last couple of days. I'm sure you're tired of hearing it, but I got to keep telling you. Please don't have any conversations among yourselves or anyone else about the persons, places, things, or charge involved in this case, and do not conduct any independent research on those things. We'll see you back here in about 15 minutes at 5 till 11. Thank you very much.
Ready. I know, Anna, you just got here, right? And you're just gonna, it's gonna just be me.
Y'all may be seated. Thank you. All right, we'll be in recess for approximately 15 minutes. Thank you.
Oh, hey. You hit the button, but I have a feeling Jesse's gonna pop up. I gotta get ready to mute him. You know? I think what I'll do is I'll pre-mute. It's because they've got the symbol up. Because Jesse has been advertising his like truth finder and coming up and making sense. And I do love Jesse Weber, don't get me wrong. Like, he's my favorite over at Law and Crime. And I did watch several of his things last night. He had something out on P. Diddy. He had several things out on Boone. And I did listen to them all. I love his sidebar stuff. But how y'all feeling this morning? We've got 15 minutes to kill. And what did you think? Seriously, anyone in the chat that wants to weigh in, what did you think of what we've seen so far this morning? You know, the law enforcement officers, I'm not sure that actually went in Sarah's favor, except for it did collaborate pictures we saw. One set of pictures we saw with the black eye. But successfully, they had to admit that George had injuries also, and that Sarah was arrested. Tomorrow, kiddo says, that was a beautiful whack flip, sorry. 10 from the judges. Yes, I was, you know. Yes, Anna, busy. I know you're working. I I do have it timestamped back, but we had 3 law enforcement officers. They did try to impeach Chelsey Koepsell again. It really didn't go fantastic for Mr. Henderson. It didn't the first time. She's a very experienced law enforcement officer, and she has done testimony quite a bit. She knew what he was up to. She wasn't going to get called on anything, and she actually kind of called him out for what he was trying to do and let the jury know that, like, no, he's manipulating the words a little bit here. Let me help you. She did do her job, but I do think that in Mr. Romero's testimony that he may have said what he said, but that's not what he said during the interview. And they do have body cam footage of the interview, which is what she would have done her notes from. So, like, his recollection may not be exact. Also, Sarah is, like, saying things too. It doesn't look credible if there's actual documentation that Chelsey Koepsell is right, and that means that Sarah could be looked at as not exactly telling the truth in several other statements she made in regards to Detective Koepsell, especially a phone call that Detective Koepsell doesn't even recall happening. And the things that Sarah is saying, she said, Chelsey Koepsell is saying, I don't recall saying any of that in, why would I? And, oh, it was Jesse. He was bleeding through. Sorry. Yeah, I do love him, but, like, although I wouldn't mind him up here with me. Wouldn't that be something? Yeah. Yep, she did, Anna. She did a really good job. And you know what really offended me? Oh, yesterday when Mr. Henderson asked if she was pregnant at the time, was he trying to allude she had pregnancy? Was that a dig? Was that trying to, like, put it out in the air that, like, maybe she wasn't thinking correctly because she was pregnant? Like, I do understand that at the end of pregnancy, there's hormones, there's this, there's, like, you can get a little bit of brain fog. But that was rude. And then he just let it hang in the air like that. Like, he didn't even go all the way there. A little bit cowardly, and, like, really shady. And that's the problem I've been having. Like, I know they got to do what they got to do. I get it. But, like, I was not impressed. Let's just say that. I was definitely not impressed and a little annoyed. Hey, Charlotte. I don't think she can overcome her previous statements or the video. And I'm sure you're referring to Sarah Boone there. I do think that the video evidence is damaging. I think that the body cam footages that come in, if they do come in, of the arrests are very damaging. Yeah. How much control do you think Sarah is exerting over her defense team? I think that when Mr. Owens visited with her 4 times before accepting this case, that they had long and I think she was quite clear on what she wanted. And I think he had to agree that that was the defense that he would do when he met with her. And I think they had a meeting of the minds. To me, it does look like a lot of this is the defense that Sarah wanted to put on all along, and could be the reason many of the attorneys had issue. This is a risky defense, the battered spouse syndrome. There is a lot there. They saw control issues. They know it could go either way. And I think that the attorneys were advising her, the previous attorneys, I mean, not Mr. Owens and his team now, but the several that left before. I think there's like 5 of them that left before. We're talking about Hobson, Maurice Podillo. We're talking about, Benkowitz in Cashman. All right. They said they had a conflicts of integrity, and that there was irreconcilable differences between them, and that the relationships had broken down. Sarah wants what Sarah wants. There is a lot of control there. I understand this is her life. She wants to be heard. She feels wrongly accused, and she has a certain way that she wants it out there. And that's her right. And it's not that uncommon that the client can actually want things a certain way. And it's up to the attorney to decide if they're willing to do that or not. Remember, they work for her, whether they're paid or not. They need to give her the best defense possible. They can advise her. But at any time, like the judge said, she could choose to ignore their advice and do what she wants. I get it. Okay. But to answer it, a little more succinctly, Charlie, I would say, yeah, I think she's running the show. Especially as often as I see Mr. Owens defer to her. Yesterday during when they decided, when they didn't do anything about the 550 pages of medical documentation that they were trying to dump on the state to use, that they were going to use in actually with their expert witnesses and etc. Or he deferred to Sarah. Sarah, you do, like, we're going to do this. Like, I did let her know, and he actually said, okay. He actually had to confer with her before he actually told the judge, we're not going to use it, even though they knew they didn't want to use it. Just spoke with lead defense attorney James Owen, who told me he's trying to finish this quickly. He told me he hopes to rest their case today. Well, that would mean that Dr. Julie Harper would testify. That would mean that the ADA is actually doing their deposition on them last night, maybe? And that came from on Twitter, Surviving the Survivor podcast. Yes, they are actually in the courtroom also. Notorious Jules had actually said she was sitting with them, and they were talking back and forth. They'd been on each other's podcasts and stuff like that. They work with Trial Live TV. I think I told you that, you guys, yesterday. Jules does anyway. She's up on their panel. They did a post show last night talking about the situation. They're both there in Florida staying. Sounds like the defense team is just as tired of Sarah as everyone else. Well, yeah, but they are working for her. I think they're trying. But I do get annoyed with the sloppiness and the lack of preparedness. I mean, at least Mr. Henderson had the interview today, like when he went to talk to Chelsey Koepsell. Well, yesterday, he asked her about 2 specific things, and he didn't have any of the paperwork. And so she didn't answer. And she let the jury know why. This defense case is moving quickly. We had 4 witnesses already for the morning. I don't think they have many more to present. The only one that I know of is Julie Warner, and they may bring Brian Boone. And it sounds like they'll be bringing Mr. Moreno back, because there's something in his statement in regards to, they want to know why, if Sarah said that he had dragged her down the stairs, why she didn't get. Sarah's thing is, why didn't anybody ask me about the things that I told people? Like, if I told you George did this, why aren't you asking me about it? Okay. And it does appear that Sarah feels very wronged by by the judicial system itself, in that George may have done things and nobody cared. Like, nobody did anything about it. But she has to remember that they also see what she's doing too. Well, she's not focused on that. As far as Sarah, it does appear that Sarah doesn't think she's done anything wrong in any of it. But we've got other outside witnesses that she can't control. Brian Boone's going to tell the truth. He's going to say why they're divorced. She started drinking when her son was born. She was depressed. The issues that Sarah has started well before she met George. She can't blame everything on George. I thought that was good information that ADAJ did bring out of the expert witness about these types of disorders that can start well before, and that the depression and the alcoholism could be a good part of it and actually make her have extreme reactions also, but it's not exactly in relationship to what George had done. Although her reaction to what George had done is altered by those facts. You know what I mean? Yep, you would think, but actually her condition started then. You know, it wasn't one she had before. This is true, Anna, because especially in Florida, they arrest both parties, which leads to a decreased amount of people calling in to get assistance because they're also going to get blamed. And I get that. I do. In some states, they arrest both parties regardless. It's difficult. Again, we go back to the point that this case is going to be used over and over again for both sides. Based on the outcome because of the BSS defense strategy that they're using. And it could hurt or help victims down the road. We're going to have to see. Just like with the Johnny Depp trial, it actually took a hit. And Amber Heard really went out of her way to construct evidence against Johnny Depp so well. It actually, other organizations like Me Too and Believe All Victims took a hit because of it, because she was a spokesperson for it, you know, and there are still people who support her no matter what. And I get that. But credibility is a thing. And she did falsify some information and she was not credible. And it takes a hit for actual victims everywhere. You know, we want people to believe and to get the help. Yeah. You're still mad about that trial? I am too. Like I did open my eyes to a lot of the situations that men are in legally and that they don't have the same resources to defend themselves against accusations anymore. And that you can actually come out against someone and just ruin their life with a false accusation because you're spiteful. You know? Yeah, they did still stand behind her rocket couch and like, you know, I would have gave them more credit if they took the hit. Yep. Yeah, evidence was clear, and I think that their reputation is like it's just so huge at this point that they're on a totally different mission than what I originally thought it was. I was very impressed in the beginning when we got some legislation changes and we had congressional hearings, but now, you know, I'm not so much behind what it has turned into now. Was like back up everybody, no matter what. There's no looking at evidence. There's no reasonableness about it. It's like just bashing powerful men in general. And I do agree that there are some really bad characters out there that needed to be addressed. I have no sympathy for Weinstein and what happened to him. I do believe that that was a good case. And I think we're coming back. Hold on. Let me just make sure. I'm going to put him up. I'll put him up like this because as soon as he goes, I'll make sure the volume is up. Yes, it is. Because as soon as we can hear him, he turns his note.
We are back on the record. 2020 CF 2603, State of Florida versus Sarah Boone.
There we go.
David K. Sharp, half the state, Boone J for the state.
Defense.
James Owen for Sarah Boone. Tony Henderson for Sarah Boone. Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is still seated at counsel's table. Yes, Mr. Owens.
Judge, we had several late witnesses that were scheduled. What was that for this?
Uh-oh. Scheduling issues.
We've excused Detective Scott Lowe. That's the only testimony of Detective Koepsell. We've just excused Abraham Marino, who's going to be recalled based on the testimony of Detective Koepsell. You've heard from the two deputies, you've heard from Dr. Bannon. Maria Gallipoli is the young lady that's outside. She was a witness as a neighbor in that complex, and she would testify about observing physical injuries to Sarah Boone. We've spoken with her over the break that that it's not necessary to call Ms. Gallipoli because we have other evidence of injuries. There was this.
Wow, they're excusing a lot of their witnesses. They're not bringing in the detective
That we're not going to call.
or Pearl that they were arguing about
So
last
that means
night.
now, calling the Orange County Sheriff's Department phone extraction expert.
Ms. Uadan.
Yes, back to the stand, and we've got 2 short videos. These are the short videos relating to Jorge Torres with a bat and then striking the TV. They're less than a minute apiece. The problem with that is because we've excused so many witnesses, that's our last witness. So we're going to be done here in probably 11:15.
They'll be done before lunch because they don't have Julie
But
Warren for
Ms.
today.
Walker is supposed to be here at 1 o'clock?
That's correct.
Okay, all right.
And then I haven't had a chance to meet with Dr. Harper, but I'm going to meet with her at lunch.
Mhm.
Oh, I meant Harper. I'm
And
sorry.
we
I
anticipate
Warner's
Dr. Harper
estate.
this afternoon. And then we may be really close to ending the defense's case.
Okay, great. Thank you for letting me know that.
But we're going to have a gap here.
Okay, so
early lunch,
well,
a
yeah.
long lunch.
That may, well, if you're saying that your presentation with Ms. Uadan is 15 minutes, I don't know what the cross is going to be. It may be de minimis, or you may be saving her for rebuttal. I don't know. Mr. J or Mr. Cacciatore,
I'm sorry.
as it relates to Ms. Uadan, CSI Tech, you're not calling her in rebuttal?
Predicate during her trial testimony during our case in chief. He said, I'm going to put in rebuttal.
Okay, awesome. So what we can do is we can proceed with Ms. Uadan, and we could just take an early lunch and ask them to be back here maybe 12:50. So that way, if we have any issues, we can address them before we start at 1 o'clock. Ms. Boone, you were sworn this morning. I just got a couple of things to go over with you. There was a list of witnesses that was provided to the court last night and again this morning as potential witnesses that may be called in your defense. One of those witnesses was Maria Gallipoli. Your lawyers have advised that they may not be calling that person as a witness in this case.
Oh, okay. They're
Do
calling
you
Pearl,
understand
but not
that?
Maria.
And again, similar to other conversations we've had, I don't want to go into any specifics of any conversations that you've had with any of your lawyers, just whether or not you've had them. Have you had conversations with your lawyers about calling Miss Gallipoli as a witness?
Yes.
Have you had conversations with your attorneys about why they are deciding not to call her as a witness?
Yes.
And similar to what we discussed yesterday, do you understand that your attorneys make trial strategy decisions, including what witnesses to call or not to call?
Yes.
Okay. Are you still satisfied with their representation of you in this matter?
Yes.
And are you still on board with the strategy that has been employed in your defense?
Yes.
Are you in agreement with the strategy not to call Ms. Gallipoli as a witness in this case?
I am.
Okay. All right. Thank you very much, ma'am. Then let's go ahead and bring our jury back in and we can call Ms. Uadan and go from there.
Mr.
All right.
Klein, can you excuse Ms. Gallipoli?
All right. Thank you very much. Let's go ahead and stand and bring back in our panel.
Mr. Owens, how do you spell Gallipoli?
What I have, Gallipoli.
2 G-A-L-L.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
I think you all can be seated. Members of the jury, once seated again, if you could confirm you complied with the court's instructions during our break by raising your hands. Record reflect all hands have been raised. Defense, you may call your next witness.
Judge, we would call forensic phone extraction officer with the Orange County Sheriff's Department, Officer Uadan.
Hi.
To the stand.
Thank you. We'll bring her in.
Please swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Good morning, ma'am. Could you state and spell your name for the record for us?
First name is Junella, Junella. Last name Uadan, Uad as in Delta, AN.
Counselor, you may inquire.
This one, again, your official title,
Digital forensics examiner.
and are you referred to as a detective or what is your?
Just an examiner.
Ma'am, Judge, can I approach the witness?
Yes, of course.
Ma'am, I'm going to show you what's been marked as identification defense exhibit AA. And you recognize that video or that CD of the video?
Yes.
Well, I think we kind of prepped you on it ahead of time. That was extracted from the Sarah Boone phone that you were asked to extract.
Yes, one of the media files, yes.
Okay, and is that video a fair and accurate depiction of one of the videos that was extracted from Sarah Boone's phone?
Yes.
And then identification Z, defense identification, same type question. You've had a chance to review that video, and is that one of the videos that was extracted from the Sarah Boone phone?
Yes.
Judge, this time I'd like to have these introduced in evidence.
Any objections?
No objection.
All right, what was pre-marked as AA will be received into evidence without objection as defendant 17. What was pre-marked as Z will be received into evidence without objection as defendants 18.
We're going to play exhibit 17 first.
You may proceed.
And is there a volume? Judge, do you have control of the volume?
Volume is on.
You're gonna help me take this shit out. Real shit. You're gonna help me take it out. You're gonna help me take this shit out. As bad as I want to.
That was it? Excuse me? Wow. I hope they have something more than that.
Judge, I'm asking you to publish exhibit 18.
You may proceed.
What? Okay, so he's guilty of violence against the TV.
Say again, sir.
We spoke about it earlier.
Yes, understood.
They're tendering, no problems.
All right, thank you very much. All right. This witness can't be released, correct?
Yes.
State.
Yes, sir.
Thank you. All
Uh,
right, can the parties approach momentarily, please?
wow. So that's the end of that? No questions? Like, why did they?
Members of our jury, at this point in time, it's 11:08. I know it's a little bit early, but due to the pacing and how quickly we've been moving through the evidence this morning, and how the defense has teed up their witnesses for this afternoon, we do not have anyone until 1 o'clock. So at this time, we're going to go ahead and take our lunch break at this time. I'm going to give you a similar instruction that I've given you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I'm going to ask you to return here to 12 Alpha at 12:50, and we'll pick up shortly thereafter. Thank you so much for your service.
Wow. Okay, so we're gonna be back at 1. It's a long lunch, like 2 hours. I'm gonna stay up a little while. If anybody wants to come up, let me know. Then I'll put some music stuff on later.
Y'all may be seated. Thank you. State, anything we need to address?
Nothing. Thank you.
Defense?
No, sir.
All right, we'll see you all at 12:50. Thank you very much. Court's in recess.
Well, this is like very. Yeah. I mean, I don't think any of us should be perfectly fine with the violence of attacking the TV. Like, I get that. Especially if there's been abuse in the relationship, I can see why Sarah would find that to be traumatizing. You know, it is violent. You know, I don't want you to think that we're all fine with it. We're not. I don't understand why they just show it and that's it. No statement, no nothing. You know, I'm very confused. You know. Yeah, in a little bit. Yeah, we'll be back at 1 o'clock. Thank you, Charlie, for your comments and for being here in the morning. We'll see y'all. Charlotte, I'm confused by that too. I know they wanted to get it into evidence because it does prove that, like, there's nothing actually showing George's behavior, and it does actually back up some of Sarah's statements in regards to his behavior. It shows that it's possible that he did act out and he could be violent, of course. So there's more than just her words. So I get that part. I do. In a totally appropriate. Of course they should do that. It was on the phone. You know, but like others have said, like, you know, I mean, my brother has thrown something across the room when his team lost. I know Jim's commented, like football players and things like that. When you get into watching the sports and all, you know, I get it. I thought that it was because it was not functioning yesterday, so they only had the pictures. Yes, they only had the pictures to show what he had done. Yes, you know what? Thank you. You're triggering my memory here. I do recall them saying that when the forensic extraction expert was on the stand. I do remember now. Yeah, that makes sense, Anna. That's so they had to come back to get it entered. That's why they held her. Okay, I get it.
Hey, everybody. Thank you so much.
All right. Oh, sorry there, Jess. I'm definitely gonna mute you there for a second, you know. Not exactly tomorrow, kiddo. I mean, yes and no. I mean, also Johnny Depp was acting out in that video. Oh, tomorrow, kiddo was saying it's like the Amber Heard recording Johnny Depp. You mean the kitchen one where he beat the cabinets? I think that's what you're referring to. You know, yeah, it's like the comments sometimes, like no big deal, drives me nuts. I get it, and it's because you work with the victims and all, and it's true. We hear it a lot. People poo-poo what they go through. We have to remember it's subjective, but you know, for both sides of it, let's not try to make it personal. Like there are two sides to every situation, and it is hard, you must admit, Anna, to believe Sarah Boone. And I think a lot of the comments are related to that, into what Sarah's trying to prove. And it is, there can be abuse even in unlikable people. And I don't think anybody's saying that George was appropriate all the time. And I don't think they're saying he's a great guy. I'm sure, you know, he was an alcoholic also and a drinker. He's got 2 ex-wives. There seems to be some issues there. But I think there was aggression in both ways. And I think that's what most people are like keying up on, you know. But true, you know, he wasn't hitting her with the bat. It's true. But it doesn't mean she wouldn't have a reaction to it. So let's be fair that way. If there is all of this going on in the relationship and he does act like that, yeah, she have a reaction. But she's calm enough to film it and document it. And so I don't think she felt too threatened, you know, at the time. But that doesn't mean, I mean, it's hard for me to believe. I don't know how you guys feel. But when she took the stand and said that she was afraid all the time, I don't see it. I don't see it in the body cams of the prior arrests of George or the interviews. Like, I don't see it. And I guess just because this is only information that I have, you know, what they are presenting to us, I just don't see the constant fear. And I'm still not seeing the imminent threat that would have triggered her. To me, it sounded like retaliation and control. And when pressed on those 9 minutes between the 2 videos, the 9 minutes where she took the bat to him, she's not able to say anything he said, even though she said that he was yelling at her and aggressive. And we heard him right before, barely able to speak because he's already begging to get out. He sounds calm. He sounds desperate. He sounds like he wants to get out, but he doesn't sound aggressive. That doesn't mean that she didn't perceive it that way. She was drunk. She was really drunk. We heard her. She won't acknowledge that she was that drunk. If you go back to her testimony and you hear the words where she says, possibly, I guess so, she does not like to admit anything about the alcoholism at all. Yes, but he made her film it, remember? Oh, he made her film it. Yes, she said he made her film it. Okay, you're going to watch me do it. This is true. And that does add an element of abuse there. Anna, that yes, that does make it a little more nefarious, a little more threatening. I get it. No, I hear what you're saying. No, she's never denied the drinking, but she really I think it does matter I think the drinking does matter for BSS. I really do, Anna. Because I don't want to push too hard because I'm not an expert either. But I'm having difficulty seeing that as a reason for her to get away with not helping George out of that suitcase. Because if she was that threatened, why did she go upstairs and go to bed? No, you mean the murder? No, oh yeah, she did. She admitted to putting him in the suitcase. She admitted to hitting him. She admitted to not attempting at all to let him out. But she still says it wasn't intentional. I have a different opinion of that. I think it was. Because I think she knew he was gone when she went upstairs to bed. It is the only thing. And I thought about it all night too. I had a pretty restless night's sleep because I did think about it for a lot last night, And I cannot rationalize with myself how she could feel this imminent threat to where she had to pick up a bat and stop him from getting out of the suitcase. But then she could just go upstairs and go to sleep. Not barricade the door, not lock it, not go next door to Brian's, not go down the road, not call the police like she had in the past. All prior behaviors that she knew kept her out of danger. She just went upstairs and passed out. So how did the imminent threat get resolved? He stopped moving around in the suitcase. She knew he wasn't getting out of that suitcase. And that's what I hope the jury's looking at too. There's some holes in her statements. There are some inconsistencies. It's Sarah's own words that make me think this. I don't know if sympathy for prior acts, bad behavior on George's part, is going to get rid of that. I really hope that there's going to be justice for his family and the people that loved him. Justice for George. Because he was not a good guy. But she's not a good woman. And they were both wrong. And, whatever. She has to be accountable for her behavior. Whatever anyone else does. And I know I'm a pain in the butt about this. I say it about a lot of things. But we can only be accountable for what we do. We don't get to control other people. We don't get to control their reactions. And whatever they do that's wrong, as strongly as we feel about it, the retaliation that we take can't be the same thing without us getting judged for it. So if Sarah feels so wrong for being abused, for being hit, for being hurt, for being taken advantage of, it's not right for her to be able to do the same thing to him in retaliation and think it's a free pass. I know, Jin. No, there were a lot. I made a list yesterday, but it's too long to go over everything. One of them is the cell phone. Like, I'm confused about that. At one point, it was downstairs, then it was upstairs. Did she go back and leave it downstairs? Because when she was talking to either the police or the ADA, I do believe she said when the phone was ringing, she could hear it because it was downstairs, so she didn't bother to go get it. And I don't know if it's upstairs or downstairs now. I don't. And about coming downstairs, that's kind of fast. She's that drunk. She says she was upstairs in the shower. But within minutes, we have a video of her drunk off her butt. And we really think that she was up there in the shower just waiting. And we saw her try to do the zippers on the suitcase, knowing she's already 2 bottles in, because we heard the slurs on the videos. And now she's saying that the video was taken almost within minutes, right? Like, there's a lot of inconsistency. She doesn't remember taking the photo, but now she remembers the video. And all of a sudden, she's so clear about the 9 minutes that happened that we don't get to see in between video 1 and video 2. And all we have are her words. And I guess things happened. He could have said stuff. He could have been trying to get out. He could have. I just don't agree with the story she's telling and how she's telling it, that he was so aggressive and so loud. When we heard him calmly begging for his life, well, not calmly, there is some desperation there, but that we don't hear him threatening her. The only cursing he did was saying that he effing couldn't breathe. I think she does remember. I don't know about the phone, Anna. I'm so confused. Yeah, Jen, we all enjoy a bottle of wine in the shower. Well, she said they were already like well into it. Like he touched her knee and said, "You're it." Like it was like they were already just sitting around drinking at that point. So they were pretty sloshed, I think, at that point. But she's saying she ran upstairs like she was totally fine, and being talked about, like asked rather about her balance and whether she was thinking fuzzy and stuff like that. She really didn't have concise on it. She kept saying things like, "I guess," or "not really," or "I don't recall." She got really bad memory about anything that might put her in a bad light. And here's the thing, like, I do think she knew he was gone when she went to bed, because when she got up, she wasn't in a hurry to go down and find him. Like she said, she heard the phone ringing. She didn't answer it. She knew it was Brian. She just, what did she say? When she finally aroused herself enough to go downstairs to look for George, that's when she saw the suitcase and she panicked. Now she's saying she gave him CPR and pulled him out and gave him CPR. And now she said that's why she didn't call 911. She was too busy, didn't know what to do. She was giving CPR. She couldn't think about it. She said he gurgled. Now, she told the 911 operator she gurgled and acted so startled when it happened, like she hadn't heard it before. But her testimony yesterday was that before she even called 911, she was doing CPR and she heard him gurgling. And this is what kept me up. The man you've been in a relationship with all this time gurgled and you're doing CPR. You don't call 911 to get the professionals there to save his life? She said he gurgled. She thought there was signs of life there. And you did nothing to get him help in that situation either. And that, I don't think, is BSS. I don't. Because she's not saying anything about being afraid or anything like that. At all. They didn't address it, Juju. I was waiting to hear about that. The autopsy would show if she did CPR. Yes. I mean, I had my doubts while she was on the phone with the 911 operators when they were instructing her. It was the way that she was talking about it that made me believe she wasn't actually doing what they said, like what they were telling her to do. But, without seeing it, you can't really say that. There was just something about it, the pacing of it, her reaction to things. Like, I understand she was upset. I mean, absolutely. Dealing with this situation. It could be that she doesn't recall anything when she went downstairs. She's totally surprised to find him dead. It could be. It could also be that he was gone before she retired. I think they do. I know I could, I set it up on my cell phone. I just have to do a little thing and it goes to 911. I don't actually have to dial 911 or anything. I'm sure there's a lot of the phones. There is a way to do that. You can enable it or disable it. Yeah. Yes, and that is why I think there is so much more that happened. I do too, and we're never going to know. Like, she's just not saying. she's just not saying. But this whole like hide and seek thing, I don't know. And now she's saying the neighbors, both neighbors, because there's two of them, and they both heard, and they both testified separately. They were in separate rooms when it happened, hearing the loud noise, and they're saying, no, that was the day before. It wasn't. This woman who has no memory of anything that happened, spotty memory at best, is saying, absolutely not, there's no way. And I don't think she should be talking in the words of absolutes at the same time as saying, I don't recall. I don't know. And I don't remember. But then she can say things like absolute things, you know. I do realize memory is shoddy, especially with drinking. I get it. But don't speak in absolutes then. Because I'm sorry, they don't exist. You know, the absolute cannot exist. Not with admitting that all of your memory right now is shoddy. All right, so I think I am going to take a little bit of break. Do you guys mind if I put some music on? If nobody's going to come up and talk, it's going to be a long lunch. So unless I hear like from someone in a while, let me just check my messages real quick on Twitter. Let's see. Nope. I definitely think I'm going to put some stuff on. Let me just see what I've got going in here. Did I upload? Let's see. Oh, okay. Let's just see if we can. Let me know if I start to robot, because I'm actually looking through files right now. Sometimes it tends to get a little crazy. All right, here we go. Just taking a minute. There we go. Oh. Oh, okay. Nope, that's not going to work. All right, I'm going to put the playlist on, and we're just going to hope for a little bit. I will be back in a little bit. I'm gonna try at least. I mean, I'll definitely be back well before 1 o'clock. When they come back, like probably it's 11:30 now, so like say 12:30, like another hour. And it unless I hear that somebody wants to come up, I'm just gonna set up. I'm just gonna check again for any questions. Dr. Berry also is doing like a little response to Dr. Bannon's testimony, actually. Hold that. I have to go down. Where did we leave off yesterday? I'm trying to remember. I think. Yep, we did read that. I did read Tiger. And we did read that one. So we are going to start. Yeah. Okay. Hold on. Wait. Oh, let me get this up. Stop this one. You forgive me for speaking to myself as I set these up, but I'm actually talking to you guys too. Here it is. Okay, let's just play a bit of stuff. Okay. There we go. We're going to start with some crease there. Oh. All right, guys. I don't want to be loved by anyone else but you. I really don't want to be loved by anyone but you. Oh, yeah. If you tell me that you love me, I will love you too. Oh, yeah, I will. I've been dreaming of your body in my arms tonight. I've really been dreaming about you in my arms tonight. Oh, yeah. You tell me that you love me, I will love you too. Oh, yeah, I will. Your sweet kisses are sweeter than the kisses of a honeybee. Your kisses are really sweet, sweeter than a honeybee. Oh, yeah. You tell me that you love me, I will love you too. Oh, yeah, I will. My sweet dreams are built to a hugging and a kissing you. Oh, I really been dreaming about hugging and kissing you. Oh, yeah. If you tell me that you love me, I will love you too. Oh, yeah, I will. I don't want to be loved by anyone else but you. Oh, I really don't want to be loved by anyone but you. Oh, yeah. You tell me that you love me, I will love you too. Oh, yeah, I will. I will love you too. Oh, yeah, I will. I will love you too. Oh, yeah, I will. Yeah, I will. Oh, yeah, I will. I will.
A reading from Bear's Library. The Raven by Edgar Allan Poe. Once upon a midnight dreary, while I pondered, weak and weary, over many a quaint and curious volume of forgotten lore, while I nodded, nearly napping, suddenly there came a tapping, as of someone gently rapping at my chamber door. "'Tis some visitor," I muttered, tapping at my chamber door. Only this, and nothing more. Distinctly I remember, it was in the bleak December, and each separate dying ember wrought its ghost upon the floor. Eagerly I wished the morrow, vainly I had sought to borrow from my book sources of sorrow, sorrow for the lost Lenore, for the rare and radiant maiden whom the angels name Lenore, nameless here for evermore. And the silken, sad, uncertain rustling of each purple curtain thrilled me, filled me with fantastic terrors never felt before, so that now to still the beating of my heart I stood repeating, "'Tis some visitor entreating entrance at my chamber door, some late visitor entreating entrance at my chamber door. This it is, and nothing more." Presently my soul grew stronger, hesitating then no longer. "Sir," said I, "or madam, truly your forgiveness I implore. But the fact is I was napping, and so gently you came rapping, and so faintly you came tapping, tapping at my chamber door, that I scarce was sure I heard you. Here I opened wide the door. Darkness there, and nothing more. Deep into that darkness peering, long I stood there wondering, fearing, doubting, dreaming dreams no mortal ever dared to dream before. But the silence was unbroken, and the darkness gave no token, and the only word there spoken was the whispered word, "Lenore." This I whispered, and an echo murmured back the word, "Lenore." Merely this, and nothing more. Back into the chamber turning, all my soul within me burning, soon I heard again a tapping, somewhat louder than before. "Surely," said I, "surely that is something at my window lattice. Let me see then what thereat is, and this mystery explore. Let my heart be still a moment, and this mystery explore. 'Tis the wind, and nothing more." Open here I flung the shutter, when with many a flirt and flutter, in there stepped a stately raven of the saintly days of yore. Not the least obeisance made he, not an instant stopped or stayed he, but with mine of lord or lady, perched above my chamber door, perched upon a bust of Pallas, just above my chamber door, perched and sat, and nothing more. Then this ebony bird beguiling my sad fancy into smiling, by the grave and stern decorum of the countenance it wore. Though thy crest be shorn and shaven, thou, I said, art sure no craven, ghastly, grim, and ancient raven, wandering from the nightly shore. Tell me what thy lordly name is on the night's Plutonian shore. Quoth the raven, nevermore. Much I marveled this ungainly fowl to hear discourse so plainly, though its answer little meaning, little relevancy bore. For we cannot help agreeing that no living human being ever yet was blessed with seeing bird above his chamber door, bird or beast upon the sculptured bust above his chamber door, with such a name as Nevermore. But the raven, sitting lonely on that placid bust, spoke only that one word, as if his soul in that one word he did outpour. Nothing further than he uttered, not a feather then he fluttered, till I scarcely more than muttered, other friends have flown before. On the morrow he will leave me, as my hopes have flown before. Then the bird said, nevermore. Startled at the stillness broken by reply so aptly spoken, doubtless, said I, what it utters is its only stock and store, caught from some unhappy master, whom unmerciful disaster followed fast and followed faster, till his songs one burden bore, till the dirges of his hope the melancholy burden bore, of never, never more. But the raven still beguiling all my sad soul into smiling, straight I wheeled a cushioned seat in front of bird and bust and door. Then upon the velvet sinking, I betook myself to linking fancy unto fancy, thinking what this ominous bird of yore, what this grim, ungainly, ghastly, gaunt, and ominous bird of yore meant in croaking nevermore. This I sat engaged in guessing, but no syllable expressing to the fowl whose fiery eyes now burned into my bosom's core. This and more I sat divining, with my head at ease reclining on the cushion's velvet lining, that the lamplight gloated o'er, but whose velvet violet lining, with the lamplight gloating o'er, she shall press, ah, nevermore. Then methought the air grew denser, perfumed from an unseen censer, swung by seraphim whose footfalls tinkled on the tufted floor. Wretch, I cried, thy God hath lent thee, by these angels he hath sent thee, respite, respite, and nepenthe from thy memories of Lenore. Quaff, oh quaff this kind nepenthe, and forget this lost Lenore. Quoth the raven, nevermore. Prophet, said I, thing of evil, prophet still if bird or devil, whether tempter sent or whether tempest tossed thee here ashore, desolate yet all undaunted, on this desert land enchanted, on this home by horror haunted, tell me truly, I implore, is there balm in Gilead? Tell me, I implore. Quoth the raven, nevermore. Prophet, said I, thing of evil, prophet still if bird or devil, by that heaven that bends above us, by that God we both adore, tell this soul with sorrow laden, if within the distant Aden it shall clasp a sainted maiden, whom the angels name Lenore, clasp a rare and radiant maiden, whom the angels name Lenore. Quoth the raven, nevermore. Be that word or sign of parting, bird or fiend, I shrieked, upstarting. Get thee back into the tempest and the night's Plutonian shore. Leave no black plume as a token of that lie thy soul hath spoken. Leave my loneliness unbroken. Quit the bust above my door. Take thy beak from out my heart, and take thy form from off my door. Quoth the raven, nevermore. And the raven, never flitting, still is sitting on the pallid bust of Pallas, just above my chamber door. And his eyes have all the seeming of a demon's that is dreaming, and the lamplight o'er him streaming throws his shadow on the floor. And my soul from out that shadow that lies floating on the floor shall be lifted nevermore. The end.
All right, we're back in attack. We have one more song for you, just one more. We appreciate everybody here. Tip your barmaids, tip your waitresses, tip the band. Why not? Drink, eat, be merry. One more song, Mac Attack. What you got, Sean?
Can't get alone. You got this man here. Why coming to my not live the night. No, I'm elsewhere. No reason to get excited. Deep got this love. Yeah, I found you. I'm lost. You and I, we've been through our days. Yeah, I see that I'm fair. So now it's not all false now. I will. I'm sorry. Oh, it's all wild, happy, proud. Make some noise right there, y'all. I didn't even know what that was. It's true, man. La, 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 la.
It's more cowbell.
Need more cowbell. La, 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 la. Mouty don't fear the reaper, following down the sun and the rain. We can be like Mouty, come on, baby, take my hand. Don't fear the rain, baby, I don't understand. Don't fear the rain.
Another one of them rock kicks.
Don't fear the rain.
One more.
Yeah. You can pull the hand me. Thank you guys so much. Yeah, the wine on my road. I see no stronger than my soul. And watch the day on your door. See my line and want to show. I've never been too bad to go. And you listen very hard. And when it's all for you, feel like you got to go. Ladies and gentlemen, to the Rainbow Boys. On the bass guitar tonight, he's every woman's dream, every man's nightmare. He's one of my good buddies. 3, 4. Ladies and gentlemen, Mr. Christopher Mounty.
Nothing like when you're being introduced to completely lose time.
He's playing all the time. Hey! Look at him cheering for you.
Ladies and gentlemen, on the whatever he's doing is Shawnee Mack rock kicks. I want the rock kicks for tonight, even though mine are much more refined. Shawnee Mack, in case you couldn't tell by the enormous banner with his visage in the background. Mac Attack! We are back every month at B&B. I am the Matty Mac. This is the Shawnee Mac. Together, the Mac Attack. Wonder Twin powers activate.
We can't do anything. She's blowing our stairway to blondes and brunettes.
True.
Thank you.
All right, color travelers, welcome back. This is DJ Kayla, guiding you through the cosmic swirls of sound, where every pulse brings a new revelation. You ever look at something so striking, like this drawing here? The way the patterns twist and pull is like the currents of our lives. No matter how far you drift, there's always that one place, that one person who's never really left you. Y'all, tonight's track is that feeling captured in melody. Kane Turner's voice dives deep into that void of longing, a soul that's lost and still searching. It's Only You I Find is more than a song. It's a confession of a love you can't forget, no matter how hard you try to run. It's the echo that keeps pulling you back, just like those spirals in the drawing. So get yourself ready and close your eyes. Let yourself fall into it. This is my 197.7 The Victory, where you don't just listen, you feel the loss.
I've been trying to fill this hollow ground, but every step sinks deeper, pulls me down. I meet new faces, searching for your shade, but every breath feels like a memory made. Your colors lingers in each quiet room. In every laugh I hear your voice in bloom. They try to hold me, but it's never right. The warmth fades quickly in the coldest night. You're the one I can't forget. No matter how I try, it's you I can't regret. The space you left, it hurts still. Every road I walk, it bends to your will. The world around me turns, but I stand still. Your memory's a ghost I can't kill. I kiss new lips, but all I taste is air. Each touch reminds me that you're not there. I thought that time would loosen all these ties, but now I see your love never dies. I'm haunted by the pieces left behind. In every heart, it's only you I find. The world around me turns, but I stand still. Your memory's a ghost I can't kill. I kiss new lips, but all I taste is air. Each touch reminds me that you're not there. I thought that time would loosen all these ties, but now I see your love never dies. I'm haunted by the pieces left behind. In every heart, it's only you I find. I tried to move, but you pull me back. Through every moment, you fill the cracks. You're the one I can't escape. No matter how I twist and shake, you're the one I can't forget. No matter how I try, it's you I can't regret. The space you left, it hurts still. Every road I walk, it bends to your will. No matter how far I run, I know it's true. I can't forget you. Can't forget you.
Prepare yourself, travelers. You've just tuned into 197.7 The Victory, where the lines between reality and sound blur. I'm DJ Kayla, ready to take you beyond the edge. Today's destination, a place unlike any other, glistens. A universe painted into existence, where each line pulses with life and every curve pulls you into a labyrinth of endless possibilities. In this world, purples and silvers become the lifeblood, flowing through the very veins of light and shadow, where time and space cease to matter. Picture this, shrinking down to the size of a single particle and traversing this cosmic masterpiece. You discover worlds hidden between the loops, realms made of pure potential, where the rules of our reality bend to your will. Every shimmer and reflection, they're glimpses into realities just beyond your reach. Glistens isn't just a piece of art, it's an experience, an invitation to dive into the unknown and dance with the guardians of light and shadow that dwell within. It's a universe alive with energy, waiting for you to explore. And now, to push the boundaries further, we dive into the raw, electrifying power of The Last Prince by Fury of Angels. This heavy metal anthem tells a tale of lost kingdoms and forgotten heroes, a sonic journey where thunderous riffs meet haunting melodies. So get ready and let the sound carry you deeper into the universe. This is DJ Kayla, and you're tuned in to 197.7 The Victory. Let's continue our journey.
Let the murmurs speak in voices from a time long past. Listen to the silence weave its tale. Let the spire call step forth, be the first to face the dark. The secrets of fate await their turn. The roads untraveled, cold truths untold. The mysteries yet to unfold. Finally, the moment is here. The descent awaits the bold. Come and touch the fire, chase the bell. It will guide you to the glow, writing tales until the end of time. Come climb the heights, face the fire. If it's on the path not taken, meet me where the edge meets the night. The answer to the question lies before your eyes, in fading stars and fleeting breaths, returning hopes and quiet dreams, carved on the spire stone, in the moment of the final vow. Building a fortress near the brink, a house of glass in a world of iron. A throne from the mirrors of the lost and the brave. Sing the verse of a tale only you can decipher. Come touch the fire, chase the veil. It will guide you to the glow, writing tales until the end of time. Come climb the heights, face the spire. If it's on the path not taken, meet me where the edge meets the night. Riding high on every hushed promise. Come alive, open your heart to fight the night's lore. Come drink deep, let the mind break free. Travel with fierce resolve, touch with fate at the end. But come cross the fire, chase the veil. It will guide you to the glow, writing tales until the end of time. Come climb the heights, face the spire. If it's on the path not taken, meet me where the edge meets the night. Come. And when the light fades into the night, the spy stands a silent guide. The prince's tale, a story told in the dark where courage and fate unfold. Walk the path of the dust may cling, for in the end the song we sing is of the brave who sought the fire and found their fate in the grand spire.
Welcome to 197.7 The Victory, where beats and stories collide in a world beyond the ordinary. Today, in the station's debut video, Mr. Victory is going to share with us something very special, the song and artwork of Thunder and Lightning, a fairy tale that he wrote over 10 years ago for his daughter. Back then, it was a story about strength, hope, and magic. But little did he know, this story would find new meaning years later. It happened when he met Amber, and something evolved. The song became more than just a fairy tale. It came to life in ways he could never imagine. This universe was born, a place where the impossible could breathe, and the rhythm of thunder and lightning could guide us through. So without further ado, here is Thunder and Lightning, from a time long ago to the heart of what the universe has become. I hope it brings the same magic and connection that Mr. Victory has found. And Amber, if you are listening, this one is for you.
Where is the light? The dark sky cried. Searching through the storm, where does it hide? Is it dancing with dawn as the earth spins slow, warming the world with a gentle glow? No, set the light with a pulse so bright. Wait for the night when the storm takes flight. Lightning in the sky, wild and free, crashing through the dark with electric glee. Thunder rolls in with a rumble and might. Together they own the chaos of night. No need for day, no need for sun. Lightning and thunder, they are the one. Where is the light? The sky asked more. Do you flicker in the day? What's it all for? But the light just flashed. That's not where I play. I saved my spark for the stormy fray. In the heart of the night, in the tempest dance, lightning strikes and thunder takes a chance. Lightning in the sky, wild and free, crashing through the dark with electric glee. Thunder rolls in with a rumble and might. Together they own the chaos of night. No need for day, no need for sun. Lightning and thunder, they are the one. Thunder chases lightning, they never part. One echoes the soul, the other sparks the heart. Through the storm, in the electric flow, lightning and thunder put on the show. Lightning in the sky, wild and free, crashing through the dark with electric glee. Thunder rolls in with a rumble and might. Together they own the chaos of night. No need for day, no need for sun. Lightning and thunder, they are the one. In the pulse of the storm, where silence breaks, lightning and thunder, that's where it takes. Through the storm's temper, in the breaking twilights, they rule the storm, they own the nights. Lightning and thunder, wild and free, crashing through the dark, just wait and see.
The next song, Phil's going to play the melody on it. So he knows it. Phil Ford's a guitar player. Kurt Bergman on drums. Lavery on bass. And I get really nervous talking in front of a lot of people. It's the first time I really played a gig. It was my gig. It was really weird. Usually sitting in the back playing piano and everybody else is telling me what to do. So I'm seriously nervous here. You know, sweat is on my brow and all that sort of stuff. Let's see. There's something I had to say. I forgot to put someone a credit, a special thanks to somebody in the program. Roberta, the secretary, does a tremendous amount of things, and like is always there when you need a key, when you need this, when you need that, and for some stupid reason, I forgot to write her name down in the program. But I just want to thank her, and I want to thank everybody who I can't see, because the lights are great, and I don't know who I'm looking at. You know, I'm being nervous. I want to thank everybody who's here, and everybody that helped me put this thing together. Thank you. Without any further ado, tell it by sound.
Reading from Bear's Library. The Black Cat by Edgar Allan Poe. For the most wild, yet most homely narrative which I am about to pen, I neither expect nor solicit belief. Mad indeed would I be to expect it, in a case where my very senses reject their own evidence. Yet mad am I not, and very surely do I not dream. But tomorrow I die, and today I would unburthen my soul. My immediate purpose is to place before the world, plainly, succinctly, and without comment, a series of mere household events. In their consequences, these events have terrified, have tortured, have destroyed me. Yet I will not attempt to expound them. To me, they have presented little but horror. To many, they will seem less terrible than Baroque's. Hereafter, perhaps, some intellect may be found which will reduce my phantasm to the commonplace. Some intellect more calm, more logical, and far less excitable than my own, which will perceive, in the circumstances I detail with awe, nothing more than an ordinary succession of very natural causes and effects. From my infancy, I was noted for the docility and humanity of my disposition. My tenderness of heart was even so conspicuous as to make me the jest of my companions. I was especially fond of animals, and was indulged by my parents with a great variety of pets. With these I spent most of my time, and never was so happy as when feeding and caressing them. This peculiarity of character grew with my growth, and in my manhood I derived from it one of my principal sources of pleasure. To those who have cherished an affection for a faithful and sagacious dog, I need hardly be at the trouble of explaining the nature of the intensity of the gratification thus derivable. There is something in the unselfish and self-sacrificing love of a brute which goes directly to the heart of him who has frequent occasion to test the paltry friendship of and gossamer fidelity of mere man. I married early, and was happy to find in my wife a disposition not uncongenial with my own. Observing my partiality for domestic pets, she lost no opportunity of procuring those of the most agreeable kind. We had birds, goldfish, a fine dog, rabbits, a small monkey, and a cat. This latter was a remarkably large and beautiful animal, entirely black, and sagacious to an astonishing degree. In speaking of his intelligence, my wife, who at heart was not a little tinctured with superstition, made frequent allusion to the ancient popular notion, which regarded all black cats as witches in disguise. Not that she was ever serious upon this point, and I mention the matter at all for no better reason than that it happens just now to be remembered. Pluto, this was the cat's name, was my favorite pet and playmate. I alone fed him, and he attended me wherever I went about the house. It was even with difficulty that I could prevent him from following me through the streets. Our friendship lasted in this manner for several years, during which my general temperament and character, through the instrumentality of the fiend intemperance, had, I blush to confess, experienced a radical alteration for the worse. I grew day by day more moody, more irritable, more regardless of the feelings of others. I suffered myself to use intemperate language to my wife. At length, I even offered her personal violence. My pets, of course, were made to feel the change in my disposition. I not only neglected but ill-used them. For Pluto, however, I still retained sufficient regard to restrain me from maltreating him, as I made no scruple of maltreating the rabbits, the monkey, or even the dog, when by accident or through affection they came in my way. But my disease grew upon me. For what disease is like alcohol? And at length even Pluto, who was now becoming old and consequently somewhat peevish, even Pluto began to experience the effects of my ill temper. One night, returning home, much intoxicated, from one of my haunts about town, I fancied that the cat avoided my presence. I seized him, when, in his fright at my violence, he inflicted a slight wound upon my hand with his teeth. The fury of a demon instantly possessed me. I knew myself no longer. My original soul seemed, at once, to take its flight from my body, and a more than fiendish malevolence, gin-nurtured, thrilled every fibre of my frame. I took from my waistcoat pocket a penknife. I opened it, grasped the poor beast by the throat, and deliberately cut one of its eyes from the socket. I blush, I burn, I shudder while I pen the damnable atrocity. When reason returned with the morning, when I had slept off the fumes of the night's debauch, I experienced the sentiment half of horror, half of remorse, for the crime of which I had been guilty, but it was at best a feeble and equivocal feeling, and the soul remained untouched. I again plunged into excess, and soon drowned in wine all memory of the deed. In the meantime, the cat slowly recovered. The socket of the lost eye presented, it is true, a frightful appearance, but he no longer appeared to suffer any pain. He went about the house as usual, but as might be expected, fled in extreme terror at my approach. I had so much of my old heart left as to be at first grieved by this evident dislike on the part of the creature which had once so loved me. But this feeling soon gave place to irritation, and then came, as if to my final and irrevocable overthrow, the spirit of perverseness. Of this spirit philosophy takes no account. Yet I am not more sure that my soul lives than I am that perverseness is one of the primitive impulses of the human heart, one of the indivisible primary faculties or sentiments which give direction to the character of man. Who has not 100 times found himself committing a vile or a silly action for no other reason than because he knows he should not? Have we not a perpetual inclination, in the teeth of our best judgment, to violate that which is law, merely because we understood it to be such? This spirit of perverseness, I say, came to my final overthrow. It was this unfathomable longing of the soul to vex itself, to offer violence to its own nature, to do wrong for the wrong's sake only. That urged me to continue and finally to consummate the injury I had inflicted upon the unoffending brute. One morning, in cold blood, I slipped a noose about its neck and hung it to the limb of a tree. Hung it with the tears streaming down my eyes and with the bitterest remorse at my heart. Hung it because I knew that it had loved me, and because I felt it had given me no reason of offense. Hung it because I knew that in so doing I was committing a sin, a deadly sin, that would so jeopardize my immortal soul as to place it, if such a thing were possible, even beyond the reach of the infinite mercy of the most merciful and most terrible God. On the night of the day on which this cruel deed was done, I was aroused from sleep by the cry of fire. The curtains of my bed were in flames. The whole house was blazing. It was with great difficulty that my wife, a servant, and myself made our escape from this conflagration. The destruction was complete. My entire worldly wealth was swallowed up, and I resigned myself thenceforward to despair. I am above the weakness of seeking to establish a sequence of cause and effect between the disaster and the atrocity, but I am detailing a chain of facts and wish not to leave even a possible link imperfect. On the day succeeding the fire, I visited the ruins. The walls, with one exception, had fallen in. This exception was found in a compartment wall, not very thick, which stood about the middle of the house, and against which had rested the head of my bed. The plastering had here, in great measure, resisted the action of the fire, a fact that I attributed to its having been recently spread. About this wall a dense crowd were collected, and many persons seemed to be examining a particular portion of it with very minute and eager attention. The words strange, singular, and other similar expressions excited my curiosity. I approached and saw, as if graven in bas relief upon the white surface, the figure of a gigantic cat. The impression was given with an accuracy truly marvelous. There was a rope around the animal's neck. When I first beheld this apparition, for I could scarcely regard it as less, my wonder and my terror were extreme. But at length reflection came to my aid. The cat, I remembered, had been hung in a garden adjacent to the house. Upon the alarm of fire, this garden had been immediately filled by the crowd, by someone of whom the animal must have been caught from the tree and thrown through an open window into my chamber. This had probably been done with the view of arousing me from sleep. The falling of the other walls had compressed the victim of my cruelty into the substance of the freshly spread plaster, the lime of which, with the flames and the ammonia from the carcass, had then accomplished the portraiture as I saw it. Although I thus readily accounted to my reason, if not altogether to my conscience, for the startling fact that just detailed, it did not the less fail to make a deep impression upon my fancy. For months I could not rid myself of the phantasm of the cat, and during this period there came back into my spirit a half sentiment that seemed, but was not, remorse. I went so far as to regret the loss of the animal, and to look about me, among the vile haunts which I now habitually frequented, for another pet of the same species, and of somewhat similar appearance, with which to supply its place. One night, as I sat, half stupefied, in a den of more than infamy, my attention was suddenly drawn to some black object reposing upon the head of one of the immense hogsheads of gin or of rum which constituted the chief furniture of the apartment. I had been looking steadily at the top of this hogshead for some minutes, and what now caused me surprise was the fact that I had not sooner perceived the object thereupon. I approached it and touched it with my hand. It was a black cat, a very large one, fully as large as Pluto, and closely resembling him in every respect but one. Pluto had not a white hair upon any portion of his body, but this cat had a large, although indefinite splotch of white covering nearly the whole region of the breast. Upon my touching him, he immediately arose, purred loudly, rubbed against my hand, and appeared delighted with my notice. This, then, was the very creature of which I was in search. I at once offered to purchase it of the landlord, but this person made no claim to it, knew nothing of it, and had never seen it before. I continued my caresses, and when I prepared to go home, the animal evinced a disposition to accompany me. I permitted it to do so, occasionally stooping and patting it as I proceeded. When it reached the house, it domesticated itself at once and became immediately a great favorite of my wife. For my own part, I soon found a dislike to it arising within me. This was just the reverse of what I had anticipated, but I know not how or why it was. Its evident fondness for myself rather disgusted and annoyed. By slow degrees, these feelings of disgust and annoyance rose into the bitterness of hatred. I avoided the creature, a certain sense of shame and the remembrance of my former deed of cruelty preventing me from physically abusing it. I did not for some weeks strike or otherwise violently ill-use it, but gradually, very gradually, I came to look upon it with unutterable loathing, and to flee silently from its odious presence as from the breath of pestilence. What added no doubt to my hatred of the beast was the discovery on the morning after I brought it home that, like Pluto, it also had been deprived of one of its eyes. This circumstance, however, only endeared it to my wife, who, as I've already said, possessed in a high degree that humanity of feeling which had once been my distinguishing trait and the source of many of my simplest and purest pleasures. With my aversion to this cat, however, its partiality for myself seemed to increase. It followed my footsteps with a pertinacity which it would be difficult to make the reader comprehend. Whenever I sat, it would crouch beneath my chair or spring upon my knees, covering me with its loathsome caresses. If I arose to walk, it would get between my feet and thus nearly throw me down, or fastening its long and sharp claws in my dress, clamber in this manner to my breast. At such times, although I longed to destroy it with a blow, I was yet withheld from so doing, partly by a memory of my former crime, but chiefly, let me confess it at once, by absolute dread of the beast. This dread was not exactly a dread of physical evil, and yet I should be at a loss how otherwise to define it. I am almost ashamed to own, yes, even in this felon's cell, I am almost ashamed to own that the terror and horror with which the animal inspired me had been heightened by one of the merest chimeras it would be possible to conceive. My wife had called my attention more than once to the character of the mark of white hair of which I have spoken, and which constituted the sole visible difference between the strange beast and the one I destroyed. The reader will remember that this mark, although large, had been originally very indefinite, but by slow degrees nearly imperceptible, in which for a long time my reason struggled to reject as fanciful, it had at length assumed a rigorous distinctness of outline. It was now the representation of an object that I shudder to name, and for this, above all, I loathed and dreaded, and would have rid myself of the monster had I dared. It was now, I say, the image of a hideous, of a ghastly thing, of the gallows, of mournful and terrible engine of horror and of crime, of agony and of death. And now was I indeed wretched beyond the wretchedness of mere humanity, and a brute beast whose fellow I had contemptuously destroyed, a brute beast who wrought for me a man, fashioned in the image of the high God, so much of insufferable woe. Alas, neither by day nor by night knew I was the blessing of rest any more. During the former, the creature left me no moment alone, and in the latter I started hourly from dreams of unutterable fear, to find the hot breath of the thing upon my face, and its vast weight, an incarnate nightmare that I had no power to shake off, incumbent eternally upon my heart. Beneath the pressure of torments such as these, the feeble remnant of the good within me succumbed. Evil thoughts became my sole intimates, the darkest and the most evil of thoughts. The moodiness of my usual temper increased a hatred of all things and of all mankind, while from the sudden, frequent, and ungovernable outbursts of a fury to which I now blindly abandoned myself, my uncomplaining wife, alas, was the most usual and the most patient of sufferers. One day, she accompanied me upon some household errand into the cellar of the old building which our poverty compelled us to inhabit. The cat followed me down the steep stairs, and nearly throwing me headlong, exasperated me to madness. Uplifting an axe, and forgetting in my wrath the childish dread which had hitherto stayed my hand, I aimed a blow at the animal which, of course, would have proved instantly fatal had it descended as I wished. But this blow was arrested by the hand of my wife. Goaded by the interference into a rage more than demoniacal, I withdrew my arm from her grasp and buried the axe in her brain. She fell dead upon the spot, without a groan. This hideous murder accomplished, I set myself forthwith, and with entire deliberation, to the task of concealing the body. I knew that I could not remove it from the house, either by day or by night, without the risk of being observed by neighbors. Many projects entered my mind. At one period, I thought of cutting the corpse into minute fragments and destroying them by fire. At another, I resolved to dig a grave for it in the floor of the cellar. Again, I deliberated about casting it in the well in the yard, about packing it in a box as if merchandise with the usual arrangements, and so getting a porter to take it from the house. Finally, I hit upon what I considered a far better expedient than either of these. I determined to wall it up in the cellar, as the monks of the Middle Ages are recorded to have walled up their victims. For a purpose such as this, the cellar was well adapted. Its walls were loosely constructed and had lately been plastered throughout with a rough plaster, which the dampness of the atmosphere had prevented from hardening. Moreover, in one of the walls was a projection, caused by a false chimney or fireplace, that had been filled up and made to resemble the rest of the cellar. I made no doubt that I could readily displace the bricks at this point, insert the corpse, and wall the whole up as before, so that no eye could detect anything suspicious. And in this calculation I was not deceived. By means of a crowbar, I easily dislodged the bricks, and having carefully deposited the body against the inner wall, I propped it in that position while, with little trouble, I relaid the whole structure as it originally stood. Having procured mortar, sand, and hair with every possible precaution, I prepared a plaster which could not be distinguished from the old, and with this I very carefully went over the new brickwork. When I had finished, I felt satisfied that all was right. The wall did not present the slightest appearance of having been disturbed. The rubbish on the floor was picked up with the minutest of care. I looked around triumphantly and said to myself, "Here at last, then, my labor has not been in vain." My next step was to look for the beast which had been the cause of so much wretchedness, for I had at length firmly resolved to put it to death. Had I been able to meet with it at that moment, there could have been no doubt of its fate, but it appeared that the crafty animal had been alarmed at the violence of my previous anger, and forbore to present itself in my present mood. It is impossible to describe or to imagine the deep, the blissful sense of relief which the absence of the detested creature occasioned in my bosom. It did not make its appearance during the night, and thus, for one night at least, since its introduction into the house, I soundly and tranquilly slept. I slept even with the burden of more murder on my soul. The second and third day passed, and still my tormentor came not. Once again I breathed as a freeman. The monster, in terror, had fled the premises forever. I should behold it no more. My happiness was supreme. The guilt of my dark deed disturbed me but little. Some few inquiries had been made, but these had been readily answered. Even a search had been instituted, but of course nothing was to be discovered. I looked upon my future felicity as secured. Upon the fourth day of the assassination, a party of police came, very unexpectedly, into the house and proceeded again to make rigorous investigation of the premises. Secure, however, in the inscrutability of my place of concealment, I felt no embarrassment whatever. The officers bade me accompany them in their search. They left no nook or corner unexplored. At length, for the third or fourth time, they descended into the cellar. I quivered not in a muscle. My heart beat calmly as that of one who slumbers in innocence. I walked the cellar from end to end. I folded my arms upon my bosom and roamed easily to and fro. The police were thoroughly satisfied and prepared to depart. The glee at my heart was too strong to be restrained. I burned to say it but one word, by way of triumph, and to render doubly sure their assurance of my guiltlessness. Gentlemen, I said at last, as the party ascended the stairs, I delight to have allayed your suspicions. I wish you all health and a little more courtesy. By the by, gentlemen, this is a very well-constructed house. In the rabid desire to say something easily, I scarcely knew what I uttered at all. I may say an excellently well-constructed house. These walls, are you going, gentlemen? These walls are solidly put together. And here, through the mere frenzy of bravado, I rapped heavily with a cane, which I held in my hand, upon that very portion of the brickwork behind which stood the corpse of the wife of my bosom. But may God shield and deliver me from the fangs of the arch-fiend. No sooner had the reverberation of my blows sunk into silence than I was answered by a voice from within the tomb, by a cry, at first muffled and broken like the sobbing of a child, and then quickly swelling into one long, loud, continuous scream, utterly anomalous and inhuman, a howl, a wailing shriek, half of horror and half of triumph, such as might have arisen out of hell, conjointly from the throats of the damned in their agony and of the demons that exult in the damnation. Of my own thoughts it is folly to speak. Swooning, I staggered to the opposite wall. For one instant, the party upon the stairs remained motionless, through extremity of terror and of awe. In the next, a dozen stout arms were toiling at the wall. It fell bodily. The corpse, already greatly decayed and clotted with gore, stood erect before the eyes of the spectators, and upon its head, with red extended mouth and solitary eye of fire, sat the hideous beast whose craft had seduced me into murder and whose informing voice had consigned me to the hangman. I had walled the monster up within the tomb. The end. Thank you for listening. If you enjoy Edgar Allan Poe, as I do, please check out the playlist of more readings from Bear's Library and consider subscribing to the channel to get notifications. Thank you.
All right, universe travelers, welcome back. DJ Kayla here, bringing you the sound of survival. Life's not always kind. Love, breakup.
Okay, I'm going to bring up the other stream now. Sorry about that. I didn't cut it at the right time. House of Usher did pretty well with this one now that I've heard the original. Oh, you mean the black cat, the couch? That was one of my favorite Poes, actually. I'm actually going to read the actual House of Usher that Poe wrote. I'm trying to get it out for Thanksgiving, but as you can hear, my voice is definitely not cooperating. All right, let me find our trial. Get that up so we are ready for when they come back. We got like, what, 4 minutes? Where's Law and Crime? Here we go. Day 4. Oh. Let's get this one up. Let's see. Is this it? Nope. Is this it? Yes. Okay. There we go. All right. So there we go. Better view to wait. Good. Let me make sure that the volume is up on that. And oh, just in time. Look. Like that. Oh, that was excellent timing, wasn't it? I'm sorry it took me so long to get back, but I didn't realize how long my read was. It was quite long, wasn't it? But I do enjoy doing them, so thank you guys for indulging me. Trying to find things to play.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Chief Justice Strong, half the state. William James, state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone. Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. She is in custody. However, there are no restraints as she will be standing as with the rest of us when our jury enters and exits. It's 12:57. State, anything we need to address?
No, sir.
Defense.
Judge, I've got something. Can we approach the bench?
Yes.
Oh no. What? I don't like the sound of that. So there's rumors that the defense wants to rest today, a whole day early. They said yesterday they would be resting on Thursday. Well, it's good news. I mean, that would mean, depending on rebuttal, that we could be done with this by late Friday. Like, it could go to the jury and maybe they will decide. But we have to see. I was hoping that their expert witness, Julie Harper, was testifying today. She's the one that has actually been with Sarah, I think 5, maybe 6 visits, and actually can give the best view on Sarah, actually, and whatever notions, symptoms, whatever that would actually apply for battered spouse syndrome in her particular case. All the information that Dr. Bannon gave was general because he had never examined Sarah and he wasn't speaking to Sarah specifically. He was speaking to victims of abuse and battered spouse syndrome in general. And I actually thought that the prosecution did a great job. ADA Will J did a great job of actually getting additional information out there on other disorders in tendencies that are quite visible in Sarah, in her testimony and stuff, that perhaps the jury will have additional information that it may not just be what it was. And he also put it out there that it could possibly be George that has BSS, that he could also have it based on what was going on. There was a lot of good information. You know what, Jester, I agree. But in fairness to the defense, I have to tell you that the first thing that Mr. Owens did, even before he became her attorney, was get her permission to negotiate with the state in inquiring about a deal. And he did bring her a deal when he came, but she refused it. And the state then reoffered another deal at the beginning of this trial, which she on the record refused against attorney's advice, I'm sure, because Mr. Owens was looking to settle this case without trial prior. Rocket says, first of all, Ann says, I'm hearing rumors the state would like to be done with the trial by Friday too. Yep, it's all over the socials. Yeah, Anna. Maybe they're hoping to get out of putting Dr. Harper on the stand, seeing the last expert witness for psychology went, and this one knows even more about Boone. That would be something. I mean, if they withdraw Julie Harper, that's going to ring loud bells to the jury. I know it does to me, that they have some concerns there. I will say that Julie Harper was hired by Maurice Padillo to do battered spouse syndrome testimony for him. But 2 weeks before trial, he had still not filed for the defense. And under the law in Florida, you have to file 30 days. I think it may be the reason he actually withdrew from the case 2 weeks prior to the trial date, and said there was irreconcilable differences between he and Sarah. Now, he had been on the case for more than a year already, and he did most of the foundation work for Sarah, and it was looking really good. But I think it is this defense that Sarah wanted that may have separated them. Of course, no attorney is going to speak on the reason. Okay, he may have told the judge privately or whatever in order to get excused from the case. It's not going to make it public knowledge. That's going to violate attorney-client privilege, you know. So, but, you know, the more I saw it with the other attorneys, is saying the same thing. And now that I see the defense that she clearly is on board with, and where it's going and what they have, I could see other attorneys being uncomfortable bringing this defense forward and thinking it's not in her best interest, that a deal for manslaughter would have been best, because she admits to everything. And if she had actually given that information to the attorneys, I could see where the conflicts would arise. You know, it just makes sense to me, but I got nothing to say that that's actually a true statement. It's just a plausible scenario. Let's call it that. But yeah, I do hope that Julie Harper takes a stand, because I wanted to hear, you know, about her conversations with Sarah. Because not once in her visits did she admit to the overt act that caused her all this panic. Maybe you're right, Couch. Maybe they're not going to bring her forward. I don't know. All I know is they've already eliminated a few people from the witness list. The other impeachment witnesses against Chelsey Koepsell have been dropped. Her partner and Abraham Moreno, exactly. I guess Mr. Henderson, in reviewing the actual documentation of the call, the interview with him actually says that, you know, just Sarah's word is not enough to impeach the Chelsey Koepsell's testimony. And it just looked floundering. Like, it didn't look very good. I mean, it could raise some reasonable doubt with the jury, but it wasn't enough for me. It's obvious that Chelsey Koepsell was doing her job and didn't have a fondness for Sarah Boone. Well, she didn't go after her because she didn't like her. I mean, I think she didn't like her because of her interactions with her and her not being honest. And they knew she was not being honest. That's the problem. They knew all along she wasn't. She refused, no matter how they pushed her, to actually come out with any of the truth. You know, back then, if she had actually owned up to any of this, it probably would have went a lot better for her. Because then when she said the words, I didn't intend.
All right, thank you all very much.
Mr.
Mr. Owens, if you could see to calling Dr. Harper at this time to advise her to be here at 1:30 for her testimony.
Oh, here we go. So, 25 minutes from now.
Just 1 second, sir. Thank you. I'm waiting for Mr. Owens to return.
Okay, so we are going to have Julie Harper testify, apparently. So that was all that. I get that. I hope that they weren't hoping that they would lie there off the couch. That would just not be. But you never know. Like, they do only look at what they want to look at, you know. It's part of the game of, you know, defense versus state.
Without Mr. Owens?
Yes.
Sure.
Okay, so Mr. Henderson is having a sidebar without the lead attorney. Well, but he did show up just in case. Wow, right in the nick of time there. Mr. Owens just walked right in. There you go. Do you think Sarah's worried? What do you guys think? Should I do a poll? I think I will put a poll up. Let's just see. How do you think the jury is leading?
All right, as we've discussed, we're not going to be having the charging conference regarding the jury instructions at this time. That will be conducted tomorrow. I've requested the defense to provide any instructions that they are seeking to be provided to the court and to the state in Word format tomorrow, including but not limited to 3.6F or 3.6G and any portions thereof that the defense is seeking to utilize for the purposes of jury instructions, then redlining the jury instructions that were provided initially by the state at the end of the evidence and testimony presentation.
I can't believe
this
the
afternoon.
defense has not
The court
done
will
this
email
yet.
those to all parties. Once Mr. Owens comes back in from making advising witnesses of when to be here, we will bring in our jury and proceed with the evidence presentation this afternoon. State, anything else we need to address? Defense, anything else we need to address?
No, Your Honor.
All right, very good. As soon as Mr. Owens enters, we'll bring in our jury. The deputies will assist Ms. Walker in the wheelchair into the jury box.
Miss Walker is the that would be Pearl Walker, I believe. That is a neighbor of Sarah's that she spoke with. That was talked about yesterday.
I don't know if she's in the process of switching lanes.
No worries. We'll cross that bridge at 1:30 if she's not here. So, okay. All right, let's go ahead and stand and bring in our jury.
Sarah's not as bubbly as she was this morning. Well, that could just be she's tired. I know I am. I can see you guys are voting. That would be what you think the jury is leaning. Now I want you to put in the chat, if you will, how you're leaning. What do you think? Let's see. I'll put this up. I feel like the defense is in this weird position where, unlike most murder trials, the burden is on the defense. There's no denial that she did it. The question is, can they prove she was justified? Yes, that's it. Because actually, they don't have to prove anything. Because the state usually needs to prove the case, right? Well, it's obvious that she did it, and she admits that part. So the state really didn't have to do much there, although they did a good job.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, everyone can be seated. Thank you. Members of the jury, again, welcome back. I hope you enjoyed your lunch. I see juror number 5th from the right to left, second row. His hand's already up. He knows what's coming. If you can, just raise those hands, confirm you complied to the court's instructions. Record reflect all hands have been raised. All right, members of the jury, the defense is going to continue with their evidence and testimony presentation this afternoon. Thank you. Mr. Owens, you may call your next witness, sir.
Your Honor, the defense calls Mr. Pearl Walker.
Oh, it's Nicole, not Pearl? Or is it Nicole Pearl Walker? I didn't even hear what he said. Well, she'll say it on the stand. Hi, Mandy. I agree with you, Mandy. I agree. Yeah.
Your Honor, just in case.
I think the deputy's got it.
Got it, okay.
Yeah, I know you're working, Mandy. I appreciate that you're listening and giving me the. This trial has really been something. I'm glad they have accommodations for her to stay in the chair. There we go.
Ms. Walker? Ms. Walker? Can you raise your right hand, please? One, please, do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am. Thank you.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
What did you say?
Can you state and spell your name for the record
Pearl
for us?
Walker. Pearl Walker, Walker.
Thank you very much, ma'am. Mr. Beck, you may proceed.
Good afternoon, Ms. Walker. Ms. Walker, do you know the defendant, Sarah Boone?
Yes.
Okay, how do you know her, ma'am? How do you know Ms. Boone? If you can't hear me, just ask me to repeat myself. And I'll
Okay,
do so.
okay.
How do you know Ms. Boone?
She lived in the same apartment building that I lived in.
And can you tell us how long the two of you shared the same apartment complex, apartment buildings?
About 4 years.
And how is it that you became familiar with Ms. Boone?
My husband and I was sitting out on the porch, and we see her coming with her 2 dogs.
And what happened then?
Then I would call her over with, with her dogs.
And what do you mean by call her over?
When I see her walking with a dog, and I see her and I look at her, and I said, "Hey, Sarah, how you doing?" And that's it.
And would she generally respond to you?
Yes.
And how, look, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes.
How long would you speak with her?
About 15 or 20 minutes. That's all.
And was your husband sometimes involved in those conversations as well?
He just say hi.
So you and Ms. Boone were the two primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. I have a mark on her arm. And I just asked her.
And would she describe how that happened?
She just say, I had a.
Hang on. The objection is sustained.
Ooh, state has another one. The bet in 1,000.
When you would ask her that, how did she appear to you to respond emotionally to your questions about her injuries?
She just say, one of them days or something.
Objection sustained.
Just for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I see the emotion that she was upset about something.
And did you ask about her obvious upset persona? Her upset, the fact that she was upset? Would you ask her about that?
Yeah. Well,
okay, you have to just limit your answer to the question. Would you ask her about that issue? About why she was. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
Was that primarily when you saw her on the weekends?
Mostly I would see her walking through, going to her place, and I'm sitting on the porch and I see her then.
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No.
Oh. How long have you been gone from that apartment complex? If you don't know, that's fine.
Oh, it's been a while.
Thank you, ma'am. During the occasions that you had to interact with Ms. Boone, how did she treat you?
Objection. She was a nice lady.
Overruled.
Nice to me.
Did she ever act uppity?
Objection.
Overruled.
Did she ever treat you in an uppity manner?
What you mean, sir?
Did she ever look down on you as a person?
Oh, no.
Did she ever treat you with disrespect?
No.
I'm going to object. This is character.
Sustained.
May I approach on this, Your Honor?
Yes.
It is character evidence. That is a good objection. Apparently they want her to testify as to Sarah's character as being a good person and treating her with respect and possibly to bolster her credibility. And yeah, that's absolutely what a defense should be doing. It's just how. I agree, Anna. Anna says that the fact that Sarah was obviously abused by George can still have an impact on the jury, and this is true. Driving that home is still important for the defense. Exactly. They're doing exactly what they should do right now. They should be bringing in people that say they saw marks, that she talked to them about it, anything that they can to support Sarah's claims in what she has said. to support how certain photos, how injuries in certain photos got there. Absolutely, because there's not a lot of support for it right now. So they're doing what they should. But the state's doing pretty good with the objections. Although there were two of them that did get overruled to allow Pearl Walker to answer. But the defense has lost most of the objections. Exactly. Charlie Hubble, I agree with what you're saying too. The jury could find her very sympathetic. They don't know everything we know. We have to keep that in mind. We know a lot more. We've seen the hearings. We've seen her actions. We know what she's been doing in the prison. They do not. They do not. We know a lot more about Sarah Boone than they ever will. Earlier, Charlie, I think they did when they talked about when the two other officers were brought in by the defense. I do believe the state did actually bring forward that George also had injuries, but he wouldn't say how, but one time he did and one time he didn't. But he also had visible injuries on him. So I think they did a little bit there. I think the video is the most damaging piece of evidence. The callousness from the couch. Trying to wipe that away is going to be hard. The words that she said to him pleading. This is a very long sidebar for such a nice witness. So the character objection is sustained. They're not going to be able to use her to give character testimony for Sarah Boone. Ouch.
I'm sorry, I'm back, Mrs. Walker. In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No, I can't say.
Did you also observe George Torres during the time that you lived there in the apartment complex?
I didn't see him very much. If we're sitting on the porch, that's the only time I see him.
Did you know Mr. Torres very well?
No.
Was there an incident when you saw Ms. Boone with a black eye?
Yes.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Objection. Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yes.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay. Did Ms. Boone complain to you about those marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Oh,
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there, 'cause we always sit out there.
Right, but we don't know if this is December or 2018 or anything
I
like that.
can't remember, sir.
Okay. And is it fair to say you have no idea how she got those marks? Is that fair?
Repeat that again?
Do you have any idea how she got those marks?
On the weekends, I see him and her go in.
Okay. But you don't know who, if anybody, put those marks on her, right?
Well,
Just calls for yes or
I
no.
can tell when they must have had an argument or something. I hear the dogs barking.
Okay. And you're 5 doors down, right? Unit 8, Unit 3?
Yeah.
No other questions?
Any redirect examination?
No, Your Honor. Thank you.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am. Ms. Walker, the deputies are going to come get you and take you out, okay?
You all done?
Yes, ma'am. Thank you so much. Defense ready to call your next witness. Yes.
said.
Yes.
Okay, guys, we all have opinions, all of us, and they're strong, and we all have different
All right,
experience.
members of the jury,
Okay.
witness is running a couple minutes late. I think they may be stuck in the security line downstairs. So we're just going to be in a short recess for them to join us this afternoon. Similar instruction that I've given you, please do not conduct any independent investigation or research regarding the person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else, and we'll bring you back in as soon as that witness arrives. Thank you again for your patience.
All right.
We all have different experiences. Some of us work in advocacy. Some of us have actually been in these types of situations. Some of us have experience
We'll
with
be off the
people with
record until
alcohol abuse.
Dr. Harper arrives.
And so we all are coming from it from different perspectives. And I'm not calling anyone out individually. Let's be clear. I just want you all to treat each other with respect and keep the snark down to a minimum when you disagree. All opinions are valid, but let's save the catty and snarky comments for the trial participants, where it is a little more fun and a lot less personal. Okay? Because this is a safe place for all of us with all of our experiences to be able to voice our opinion. And the last thing I want to see is people going at each other in the chat, okay? Not that that has actually been really prevalent, okay? I'm just picking up a little bit of snark that I would appreciate get toned down, okay? Because I want everybody free to express their opinions, where it comes from, their experiences. It's all valid information, and it's all of value. All of your voices are valued. Okay? So, and that's not in particular to any one person. It's generalized. It's something I have to remind people in these kinds of situations a lot, including myself, because I can get quite snarky about stuff myself. And I'm very guilty of it. We all have strong opinions. We all have life experience. We all have been in situations, and we all make our opinions based on that. And we interpret what we hear in these trials and the information with it. And that's why I want everybody free, regardless of what your opinion is in regards to any of it, the ability to express that freely. Okay? And you're going to have people that don't feel the same as you. And we all just have to respect that and allow them to have the same freedoms that we do to voice our opinions. Okay? You're different, just like all the different people, Rodin. Yes. So, of course, our defense witness for 1:30 is going to be late. And, well, we'll just sit this up here and like that. And while I was busy being nervous, did anybody catch what time they said she was coming, or is she on her way? No, I do believe it's going to be Dr. Julie Harper, right? Charlie Hobo says, let me just get that up. In my opinion, both of them were capable of abuse for me. The video says it all. I do believe it was contentious. I kind of agree with you. I think they both were violent. I do recall the ex-husband's, the body cam footage of the interview that Chelsey Koepsell and Detective Alden did with Brian Boone. They did say 1:30, but now they said late, Anna. I saw that, but Like, I was just wondering what the last comment the judge said. Yeah. Oh, she's stuck at security. Thank you, Shill. Okay, so that won't be too long. But anyway, do you guys remember Brian Boone's body cam interview with the detectives? And he had said during his marriage, when Sarah was drinking, she became aggressive, and he became physical, and he had often had to restrain her, but he never hit back. He was a different type. We all know in these situations people react differently. But that testimony alone there kind of proved the aggression. But the state did not bring it in the beginning because they weren't allowed to talk about prior bad acts. And that includes Sarah's. So they could not question him on it. But he was reserved. And I noticed that the state did not bring him in to talk about all of the times Sarah went to him saying what was going on with George. I mean, let's be honest, Sarah herself has said that the one she went to all of the time was Brian. He would have been the witness to confirm everything she's saying about these incidences, but that would have opened the door for Brian to also say he's been in these volatile situations with Sarah before and that she's an aggressor. So that was very clever on the defense's side not to do that. But this is why there's not a lot of supporting evidence for Sarah talking to people about what was happening, because I do believe Sarah did tell Brian every time that something happened, because, you know, she was saying things to the brother. She was like, tell him how you choked me. Tell him how you did this. She was mentioning it to anybody who knew George or knew them. She was making remarks to people. She told the maintenance supervisor that he grabbed her by the hair and dragged her down the stairs. Who is Dr. Harper? Dr. Julie Harper is the forensic psychologist who actually has seen Sarah Boone several times. She was hired by previous attorney Maurice Podillo back in 2021 to actually do a profile on her to see about the abuse and actually to explore battered spouse syndrome for the defense back in 2021. And she has since seen Sarah several times, because I do believe it was also Mr. Hobson, Mr. Bankowitz, and Miss Cashman who actually were going to go by some of her affidavits and views. And so she was asked to be seen again. Then when Mr. Owens took over, he had her come in and see and refresh her recollections by actually sitting with her again. So she is going to be the expert for the defense on actually Sarah's qualifications as battered spouse syndrome, like what her symptoms are, what they see in her, and how they feel about it, and be there. So that's going to be quite interesting, because there's a lot of information there, and it's a good one for the defense, okay, because she has actually examined Sarah, not like Dr. Bannon, who gave generalized information in regards to the condition, how the law is, how you testify to it, what other signs and symptoms there are, what are the normal scenarios, you know, yada, yada. And then the state actually got even more information out of him about other things, like the narcissistic traits, the control issues, you know, all of this. So that the jury got a lot of information on the basics there from an expert. And he was very, very well educated, and he knows his stuff, okay? But he had never examined Sarah, so he could not attest to any of this in regards to Sarah in particular. However, Dr. Julie Harper
on the record.
Can.
Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Judge, before we began trial, I had indicated that in the past, historically, in these types of cases, there were problems with cameras showing attorneys' laptops. It's been brought to my attention that that is going on again. I'm asking the court to order whoever it is who has a camera, whether it be phone or the court TV pool camera, that they not do that.
Okay. All right. Members of the gallery, good afternoon. And the TV crews as well. Information that's contained on both parties' laptops, be it the defense or the state, is protected by work product and attorney-client privilege. It's not something that's viewable, not something that should be disseminated, and not something that can be looked at unless there is a knowing, intelligent waiver, and that stuff's going to be put out to the public for consumption. So I'm going to ask you as best as possible not to view, take pictures of, or look at any of the laptops, be it the defense's laptops or the state's laptops, to avoid that. With regard to the camera, if we can, when zooming in on either the defense counsel's table or the state's counsel's table, if we can try to avoid their laptops, I would greatly appreciate you, sir. And the podium. Thank you.
Okay. Where did the volume go again? I see him talking, but it looks like it got muted. I better check that. Is that the feed? All right, hold on here. I'm going to refresh this feed for a second, guys. I hear the white static noise of the... Okay, it is their feed. It does appear that Judge Kraynick has pushed the button. And to answer your question, Charlie, like, can they recall Brian Boone? In regards to this, they can if it's in rebuttal to other testimony that was given. Yes, they can. So if they can find a way to bring it in, perhaps they will. I'm very curious about the rebuttal case because there were quite a few things that were not addressed that we all have questions on. You know, I don't know their long-term strategy, and I'm not going to try to second guess them. I'm not a lawyer, but there are also constraints on what they could talk about based on motions they made themselves on prior bad acts and stuff and character witnesses, and what the state and was attempting to do was not to try the victim. In other words, they weren't going to let the defense put everything in regards to Jorge Torres up and try him like he's guilty when actually Sarah does admit that she did zip him in the case and she didn't let him out. That's the issue there. They are allowed to talk about prior bad acts that affected Sarah in regards to her mental perception and her current state of emotional status, you know, her emotional status in regards to being an abuse victim. They're allowed to bring all of that in, you know. I think if they want to impeach her on issues, they can, Mandy. Mandy is asking if the state can actually call Sarah Boone. Yes, I do believe that they can. Although they did have an opportunity to cross-examine her, the only way they can bring her back for rebuttal is if there actually is something that needs to be cleared up in the testimony.
Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Chief Justice Strong, I have to say.
Defense.
James Owens on behalf of Ms. Boone.
Tony Henderson for Ms. Boone. Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse. Let's go ahead and bring in our jury as Dr. Harper is here.
What I meant when I said that, Mandy, is they don't get a second crack at her for anything, for everything. They have to have specific reasons, and it has to not be redundant. Like they're not going to get another crack at her like they do in Cross. And even in Cross, they only can address things that she said on the stand or things that were brought up. They don't get to bring new stuff in. It's not their witness, right? But and they weren't going to call her to the stand as their witness in the beginning, based on like the strategy for the battered spouse syndrome. Yep. I agree. There's a lot of holes to poke in that testimony. I think the jury's tired.
Yes, Your Honor.
Defense, you recognize our jury. All right, thank you. All could be seated. Again, members of the jury, if you could just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time you may call your next witness.
We call Dr. Julie Harper.
I hope you all have a beverage and your snacks for this one. It's going to be a little longer, right? At least I hope so.
I do.
Doctor, good afternoon. Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name, but just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people. I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington. As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is a community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working during the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just quieted down, of course, from COVID, and I was not in full-time practice, so I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the Panhandle of Florida.
All right. And is that where your practice is currently?
Yes.
All right. Is it fair to say you travel the state to?
Bless you.
Is it fair to say you travel the state to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then of course working along.
Is it fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right. And when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
Okay. You said that your practice is now entirely forensic?
That's correct.
What you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing hearings. I've been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert in what's called social investigation. That's what they used to call custody evaluations. So in numerous capacities.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide and you're paid by the state?
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. Now, I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete, and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would, need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you can have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person, or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution.
Yes.
And you've testified for the defense.
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Are there times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and then it's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Miss Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Miss Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have been.
How many times did you meet with Sarah Boone?
So 9 times.
All right. Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Well, we had a clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay. So you considered some medical records?
Yes.
And did you also consider some records from Jorge Torres's records?
I did see his hospital records.
Now, do you consider in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with...
Conduit 704.
Approach.
Was that actually or an objection based on content that no I don't understand. Anybody? They're gonna just talk about, like, I do believe that part of the assessment is like her childhood upbringing and things like that. That can come in. But perhaps there's a character issue here, since they're not allowed to talk about character issues. Like, maybe the state is trying to prevent this in a way. They, like, I can see why they would think the jury would be sympathetic. So they may be trying to not have her testify to that area, but
the objection is sustained.
Wow, and it worked.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Objection, leaving conduit 704.
Sustained.
Yep, that's the same
You considered
objection.
the
Cut
entire
it out,
family
Owens.
background and history, without going into the details of what she said or what you learned from looking at records. I'm sorry?
Yes.
And did you consider her relationship with her mother as part of her psychological development?
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
That's because
Can you
narcissism
elaborate
itself
on or
is
explain
very hard.
how you feel that
5%
Sarah Boone does have
can
some
qualify.
narcissistic traits?
Well, in meeting with her as part of the evaluation, The narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
The DSM.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
Now, Dr. Bannon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that from this manual and your studies and your experience, where they require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to that.
What I'm getting to is many times you may have these narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to the
If I'm allowed to reference the DSM, then I can explain it best.
Just don't read from it. Just
all right.
You need to review. If you need to read a paragraph and then explain it to the jury.
So based on the description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities, because at root, they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that issue?
Well, you asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Are there criteria?
There are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder?
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her with narcissism, that disorder.
That's correct, because the DSM's description guided me that that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Boone with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Have you diagnosed her with anything? And we'll elaborate on that, but through your assessment,
Have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder. She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this incident, this event, we're talking February 23rd of 2020, you were aware that she did not have much family support?
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help assist me in making sure that the person is intending to put in good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type of thing?
Right, and so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Okay. Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller Forensic Assessment of Symptoms test is.
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms that would be unusual or not typical of a valid psychiatric patient.
What were the results of Ms. Boone's test on the Miller Forensic?
She validly participated. There was no indication of any feigning or malingering.
And as far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff that would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician-administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
At the time that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
or tell me the results.
Yes, so the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test, that wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms, that was consistent with the outcome of that test.
And would this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma to after the alleged trauma? And I'm referring to the trauma. We're going to talk about what the trauma was, but the trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to make your decisions.
No, I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in their arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes,
Did you consider the previous diagnoses in arriving at your own?
I did. Yes.
What did Ms. Boone, what had she been diagnosed with prior to you getting involved?
Section 704 conduit.
Approach.
He does not want us to hear the arguments on this objection. He does, well, not us so much as the jury. He likes his objections up there. There's something to go back and forth in sidebar, and I give him a lot of respect for that, because hearing the attorneys back and forth, even if told to disregard, it is hard for the jury to separate that out. Hey, Beck. Charlie asks, how does PTSD, post-traumatic stress disorder, affect the circumstance? It does in regards to her state of mind, the condition she may or may not have been in at the time of the incident. There's no doubt she did not let him out. There's no doubt she helped restrain him in the suitcase, whether he got in there willingly, what? You know, we have no doubt about any of that. Thank you. I appreciate that very much, Beck. And I'm glad to have you back in the chat a bit. I did find that Julie Harper, like, this is very pertinent information. She has at least examined Sarah Boone. She's got experience with Sarah Boone. She admits about narcissistic tendency, but like we were talking about earlier, that venerable narcissism is actually a form of narcissism, and it does have very, very low self-esteem. And a lot of this bolstering could be a road how that actually is going to be worked in with the abuse at all. Remember, the jury needs to convict her unanimously, and they need to decide that regardless of what is going on with her, it was not reasonable to leave him in the suitcase. That's the issue. She says she was afraid for her life. It's going to be interesting. At this point, let me look at the poll, actually. Okay, so I did ask you all what you thought in the chat, and most of you said guilty. That regardless of what was going on, she should let him out of the case.
The objection is sustained.
And you guys think the jury does also. And the state
But
has
would
won
agree,
another
I think this is
objection.
a fair question. You would consider prior other experts who may have diagnosed her with something.
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time when I diagnosed her myself.
Okay, given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder. It's my opinion at the time of the offense, she had depression and she had an alcohol use disorder.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely
Sustained.
You have viewed
Exactly.
Have you viewed some exhibits involving her being stabbed?
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Right, you're saying?
Overruled.
Just generally, without getting specific, I think I've explained post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Post-traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping. So their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all features.
They have trouble sleeping.
Yes.
Sleep deprivation is a real issue.
It's associated with things like nightmares and having trouble settling.
Now, you mentioned that you had diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
And alcoholism can be depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in diagnosing?
Yes.
The many people who suffer from alcohol use disorder, I don't know how to put this, are they in denial?
I would say that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have a problem.
That's right.
What is the difference between traits and a diagnosis?
Well, we all have personalities, and so you're going to have coping mechanisms that include personality styles. So for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like, and that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across like all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes, so the diagnosable condition would be PTSD or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware that that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case.
Yes.
In a criminal context.
Yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because, of course, they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
And just briefly touch on, because I know Dr. Bannon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event. So something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's like called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically, the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim is getting abused, and you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone or some small behavior that might not mean much to another person, but it has preceded other violent acts. So, for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home. And that could be a signal, like abuse and violence has occurred in his stay-at-home clothes, for instance. That might not mean much to another person because, again, it's specific to that dyad. Those two people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hypervigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you've diagnosed Sarah Boone with. When those personality changes occur and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change like in their sleeping, in their hypervigilance. That's when you can diagnose it. So you can have a trauma or an experience of, scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
Then it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur.
Yes.
When a threat was about to occur.
Yes.
Threat of danger.
That's right.
Now I want to talk about placating the abuser. A victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal, in which the battered woman may attempt to reduce through several different means to delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. Doesn't always stop it.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's a strain. sharper words come out. I think that that is the way that she would try to respond to Mr. Torres. You can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation?
Yes.
Suicidal thoughts?
Yes.
Substance abuse?
Yes.
And there are often physical signs of injury such as bruising?
That's correct.
Chronic fatigue?
Yes.
Learned helplessness?
Yes.
Can you tell I know Dr. Bannon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked, and the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference, so don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that one of the conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where, like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on. And it seems like denial. In other words, your coworkers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them?
Yes.
And they're numbing their emotions to it.
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it, because numbing it means that you can keep that relatedness no matter how bad it's getting.
Does some people with this syndrome disassociate?
Relevance. Approach.
Okay. All right. Yes, we got more. Lots of objections going on. Nice little side view with the camera there, like Sarah. Not too happy with them watching you. Sarah does not look as comfortable today to me. Mm.
Objection to relevance is overruled.
It is
I agree
relevant.
that battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience.
Some people do experience that.
I'm just going to list some of the symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance.
Yes.
The panic attacks.
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
Very low self-esteem.
Yes.
Poor body image.
Sometimes.
Feeling that they have no control.
Yes.
Sexual dysfunction.
It can be, particularly if the trauma includes sexualized attacks.
Short-term memory problems and confusion.
Yes, that's part of PTSD sometimes.
And they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
Fear.
Yes.
Constant fear.
That's correct.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
Approach.
Okay, I can understand why they're objecting there, because now we're going to go into George, or what the jury will perceive as them talking about George when they say the word abuser. So I do think that this state has every right to object here. This psychologist only spoke with Sarah. She looked at the records. She did go over George's medical records, but she did not have any contact with him nor a discussion with him. So she can only give a generalized answer in regards to things an abuser would do, and can only really talk about the concept of abuse and what that contains. Do you know what I mean? I mean, that's the only fair thing to do. So it's really the way Owen is asking the question that's the problem, not the information that's trying to come out. I'm sure the state is arguing way too prejudicial against the victim. I agree, Anna. Looking at Sarah, I agree that this testimony is probably very difficult for her to hear. Although this is great for her defense, based on the situation in her defense mechanisms and everything, of course. They said that the way Sarah mentioned the stabbing, Mandy, did lead the psychologist to believe that that is one of the triggering events that she recurs to, because it was so painful and it meant. And even when she talked about it on the stand, you could see how animated she was. It is something that basically could be a triggering for her. But not the triggering event for the night of the incident, but a triggering PTSD event, something she keeps going back to.
All right, you may proceed, sir.
Part, I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting.
Yes, that could be an overt act.
Kicking.
Yes.
Punching.
Yes.
Choking.
Yes.
Burning.
Yes.
Using weapons to hurt you.
Yes.
A knife.
Correct.
Curtain rod.
Yes.
Threatening to hurt you, your children, or your pets.
Yes.
Belittling and humiliating you.
That's correct.
Taking your car keys.
That would be considered a form of control. So yes.
Controlling your money.
Yes.
Control where you go and who you see.
Correct.
And who you can talk to.
That's right.
Force you to have sex when you don't want to.
Yes.
Stalking you.
Yes.
Slapping you.
Correct.
Do you agree victims that suffer from this abuse experience feelings of anger?
Yes, that can be in some of the phases.
Sadness?
Yes.
Hopelessness?
Yes.
Worthlessness?
Correct.
Intense feelings of fear?
Yes.
Abusers have a tendency to have low self-esteem themselves.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself.
Yes.
Have a desire for power and control.
Correct.
Have a tendency to use alcohol or drugs.
Yes.
Abusers oftentimes have temper.
That's correct.
Become jealous easily.
Yes.
Very possessive.
Can be.
The victims can suffer from severe psychological distress.
That's correct.
Is that what Sarah Boone suffered from?
Yes.
Yes, sir.
Dr. Harper, I'm showing you Exhibit 14, this is 5 photographs. Did you watch the video of the TV, the Bannon TV?
I did.
You considered that in your analysis and your diagnosis?
Yes, I did.
And I'm going to show you some pictures. Exhibit 12. I believe she's testified. This is where the curve line. Are you familiar with that?
Yes.
Exhibit 11. Are you familiar with this photograph over here?
Yes.
Exhibit 10, which is her arm. Are you familiar with that photograph?
Yes.
Exhibit 9, picture of the bloody knee. Exhibit 8, picture of her black eye.
Yes. I've seen these.
Picture, exhibit 7, picture of her, Sarah's lips and something, eyebrow.
Yes.
And this is a composite exhibit 6, which is of the stab for the weapon. Are you familiar with those?
Yes.
And I don't know if you've seen this exhibit 5, is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen a medical record associated with that.
Of that burn.
Yes.
Exhibit 4.
Yes.
See with that? Looks like exhibit 3. She was slapped on the tongue.
Yes.
There was a lot on the socials in regards to the black eye photo. Many people were saying that they were not really believing that that black guy was a black guy, which was bizarre of all the pictures, you know.
As it relates to Sarah Bannon?
I mean,
Yes,
people
under
have
the
different ways.
substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times, to visit with someone like this to build trust?
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times, they're very slow to open up and tell you about the abuse.
That is correct.
And they'll actually often lie about it.
Deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's a result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there any, did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and given to this group?
Yes.
That's all the questions I have.
Okay.
Any cross-examination?
Yes, sir. Good afternoon, Dr. Harper.
Good afternoon.
So you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert, yes.
No, man, what I'm talking about is you just went through that you had 9 visits with Ms. Boone, correct?
I did, yes.
And that was over the course of 8 different days because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get one crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right. Specifically, when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the issue? Oh.
Judge, the question.
Legal objection.
Objection.
Legal grounds.
He asked a question about battered spouse and insanity.
Yeah, you can't just stand up and start talking like that in front of the jury, Mr. Owen. Like, you've been told about this. Object formally and then sidebar. Yes, you know how the judge likes it. Bad legal manners for anybody who's playing bingo. I call bad legal manners on Owen again. Okay, just for the bingo card. That was all.
Objection sustained.
When it comes to an affirmative defense such as battered spouse syndrome being used for self-defense or, not and, insanity, it requires a court order for the state to go have an evaluator go, right?
Yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response like a mental disorder. So first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth?
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth, correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic.
They could.
Or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual by an intimate partner as well, correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, cues for that person, and also working with law enforcement, they become seasoned to micro traumas. So almost every police officer can remember the first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, it's not what I said.
I'm not saying you did.
Okay.
What this battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping, I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally it was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things, why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach. Question withdrawn. You may proceed.
Okay.
All right. So you would agree that hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Okay. Propping one up, hypothetically saying, I'm the best thing that has ever happened to you, you'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of a potential exertion of control over an intimate partner when you give somebody hypothetically a bike, but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Now I'm asking yes or no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit. Okay. Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Thank you. Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase, you would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her.
Correct.
And she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different, hypothetically, than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids, than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's right.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father, correct?
Right.
A better ex-husband.
With phone calls. Yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia, or indicators, sorry.
Understand.
I know you know. That perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that. Like, make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, you know, she was low 40s when she met you 4 years ago?
That's right.
So she had been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
Oh, you said for 24 years, and that's why I was confused. You can't be 18 for 24 years, but 24 years ago, I would agree.
Did her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband, was lump sum plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
And it was Mr. Torres who would work, correct?
He worked at Ace Hardware.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you Well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
And that her child had gone to school and reported it, correct?
Yes.
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
That's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Ms. Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes.
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
That's right.
And February 24th of 2020, the child was scheduled to be picked up by Miss Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes.
Object.
That's that. How can you object to that? That's a statement of fact. She said it in the interview. Wait a minute. I'm confused. Okay, I'm really curious as to where this one's gonna go. Anybody with me? She literally did say that in the interview. Why can't he say that? That's a statement of fact. She said it. And I think it's a valid to ask the psychiatrist why she would swear on her child's life.
Objection sustained.
Oh, damn. He doesn't get to ask. Okay.
She
She's
swore
going to
on her
rephrase
son's
it.
life that it
Okay.
was not intentional that she ended up killing Mr. Torres, correct?
That.
I object.
Roach.
What? It was a yes or no. She just says yes or no. Okay. Because they want her to be able to answer that why she would do that. And I think I know where that's going. She would actually swear on her child's life because Sarah Boone does not believe she intentionally did any harm to George. Although she hit him with the bat and she didn't let him out, she doesn't think that not letting him out of the suitcase was intentional harm. And she's sticking by that. In her mind, he wasn't in any danger. She was the only one in danger. Because it's so prejudicial. First of all, it sounds horrible, doesn't it? You swore on your child's life that you had no intent, and yet George is
Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever.
Right.
Mr. J, you may proceed.
So
She's quote unquote swore on her child's life that it was not intentional. That. Correct?
Before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you. It's on video. Some of Miss Boone's diagnoses predated her relationship with Mr. Torres, correct?
Yes.
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon you see, correct?
Well, I wouldn't say that all mental disorders have an independent cause. Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had these.
Also, yes or no, ma'am?
Yes, she did.
Thank you. You reviewed some Advent health records, correct, of hers?
Yes.
And some Aspire records of hers, correct?
Yes.
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
Yes.
And there is a time when she goes to the hospital where she is described, their words, not mine, as having ETOH on board.
Yes.
Do you understand what ETOH means?
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes.
Drinking alcohol, not the other stuff.
Correct.
And in the records that you reviewed from Aspire, She came with complaints of depression in January of 2018, correct?
That's right.
And ethanol or alcohol is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist. So let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
Generally, yes.
And you diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking? For instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you familiar in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like, I try to identify that.
And do you ever ask if somebody says they drink 2 glasses of wine, well, how big are the glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
And in January of 2018, when she came in crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165, correct?
I believe so.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
Wow. I do believe that the prosecution just exposed bias.
So there have been 2 sets of records, but I believe you may have the same set that I received on September 27th, 24. Can you turn to page 21 of 57 of the Aspire records?
mine aren't numbered, but I will.
May I approach the witness?
Yes.
She does, but it's because he's asking her specifically about the blood alcohol level, and she may not be confident to remember it exactly what it was. How did they do what? Exposed by it the same way that the defense was trying to expose that Chelsey Koepsell didn't like Sarah Boone and that she might be biased. I think that question just pointed out to me the psychologist's reaction to it was very defensive about the wording, meaning that they weren't going to be on board with you depicting something in a certain way, being very protective of Sarah as a client patient.
What I'm showing you is what is,
so to speak. That's what I mean by that. If that's what you're asking, Rebecca.
provided to me by the defense on September 22nd, 2024. And just at the
Yeah,
top,
the word stumble. She doesn't like the connotation that she was so drunk she was stumbling when she knows that Sarah told her she was approaching the police for help. That's what I mean. Like there's a difference there. Bias between the prosecutor and the psychologist. That she wants to make it clear that she's not on board with that. Oh, you mean not the blood alcohol level? The word, I know she's offended by the word stumbled, Mandy. I agree. That's what I meant by exposing like the thing there. She's not going to get on board with it because of what it infers. You know what I mean? Yeah. So they're going to go back and forth about that. Like, and I don't blame them because that word, the word stumbled has a connotation with it. And yet the approach an officer for help is a totally different connotation. Yes. Yeah. But the blood alcohol level is extreme, Mandy. Would you not agree? Like, yeah, there's really no contesting that. It doesn't matter. Like, if it's off a couple of whatevers. She was obviously drunk. And also, and I see your comment above too. I understand, like, it is very hard for people to understand why people would go so far in these conditions when you have PTSD or any kind of traumatizing event you're in these situations. Why you would go so far, and make such broad statements like "I swear on the life of this" or that and everything to do. But actually, I don't think Sarah feels she had any intent to kill George. I believe she strongly believes that she had intent to protect herself. But it is actually depraved indifference to leave somebody in a suitcase to smother to death, to be asphyxiated, especially when it's
You may proceed, Mr. J.
Thank you. All right. In October of 2018, or of 2018, there was a second visit to Aspire, and that was based upon her being found stumbling by law enforcement with a .185, correct?
She walked up. Okay. So I'd have to say no, the way you phrased the question.
See?
Ma'am, Boone was stumbling due to her level of impairment, .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
That's what he's saying. That's what the record says. So she has to agree there. But she knows what Sarah told her, and she doesn't want it portrayed that way. That's what I meant by
When you
bias.
talked to Ms.
There
Boone
you go.
about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had two different Baker acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
No.
No, I'll show you what she said. That's what he's going to do. Okay. He's
Do you
being
remember
very
giving a
calculated
deposition
here.
on October 1st at the state attorney's office downstairs?
I do.
And at that point in time, and I'll ask closing part, you want me to?
He's going to go right to her deposition.
Show her prior statement before I.
And Sarah.
She's got a deposition.
Do you have your transcript?
I do.
Okay.
Just.
So for the record, it's page 34 that I'm referring to. Line 16, 17.
Yeah, but it is actually in the record that way from
I'm with you.
the medical professional at the time of the visit, Anna. That's what he was referring to. He didn't.
That's what I said in my
words
deposition, that she
in the
was
record that way.
describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes.
And ends up going to what we call Lakeside Bend and Aspire now, right?
Yes.
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were two separate incidences. January, when she came looking for the pastor, correct?
So I'm just clarifying that there's a record that we started with this conversation from October of 2018. And there is a description of her trying to go to the hospital to seek a counselor. So those are two different instances.
Right. In January of 2018, when she went to the hospital crying and signs of depression,
Bless you.
She indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
So the hospital records are not referencing her relationship with George on the January date.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
And she indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
And those include photographs of Ms. Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp. So I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
And did you ask her how it was that she was injured during this dragging down the stairs?
I don't think I went through specific injuries to her. No.
Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you, patient, or a client?
If they're actively intoxicated, yes.
We had talked, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
You're talking about the criterion of narcissistic personality disorder? Yes.
It's like page 761 on your hard copy.
Thank you. All right.
Or my close. I have a digital copy.
760, but.
One of the criteria is has a grandiose sense of self-importance, for example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
Yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
That he or she is special and unique and can only be understood by or should associate with other special or high status people, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criterion.
4 requires excessive admiration.
Yes.
5 has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6 is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Bingo.
Is interpersonally exploitative. Agree.
7 lacks empathy, is unwilling to recognize or identify with the feelings and needs of others, correct?
Yes.
8 is often envious of others or believes that others are envious of him or her, correct?
Yes.
9 shows arrogant or haughty behaviors or attitudes.
Yes.
Now, you believe that she has traits of that disorder, correct?
Yes.
Which one? Grandiose sense of self-importance?
There are indications that she feels like that or has expressed that before.
So that's a yes.
Yes.
Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love?
No.
You remember going to the state attorney's office on October 1st of 2024 and giving a deposition?
I do.
Teaching her answer because she did answer yes before
You swore to tell the truth, the whole truth, nothing but the truth, correct?
in the deposition.
And referring to page 89,
Now
lines
granted.
18 through 20.
Okay, I'm
Let
gonna
me know
take
when
this.
you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement,
Yes.
is not interpersonally exploitive,
Correct. It is not.
and when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware if she's inconveniencing others.
So there was 3 of those traits, correct?
Yes.
Not 5, which would be required, correct?
Right.
For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right. During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were the text messages that were part of the phone extraction of her phone device, correct?
That's right.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control, jealousy, easily angered.
This could be, yes.
What other traits for just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent, like life, job, money, things like that, that would be supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
Specifically, the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes,
Medical records for Mr. Torres.
that's right.
The medical and Aspire records for Ms. Boone that we discussed.
Yes,
The crime scene photos from the incident in February.
that's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving the suitcase.
That's right.
And additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV.
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres?
Yes.
One prior 911 call?
Yes.
Now, today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Is that recently?
No, there are photos included with the
The prior case packages?
case packages. Thank you. I'm not sure what to call it. So
That's fine.
All right.
All right, and did you review any body worn camera from those prior case packages?
no, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Are you speaking of documents only?
Yes, materials other than your 9 visits with Ms. Boone.
All right. Just checking with the folders I prepared for today. I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Okay. Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton?
All right. Anybody else?
No.
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No.
And you didn't review the phone text messages extracted from her device, correct?
No, I didn't.
Did you review any records from the jail?
No.
And yes.
The defense doesn't like the idea of indicating that they may have not given her everything, but that's not unusual. Either if you're a witness for the state and or the defense, whoever you're the witness for is in control of the information they give you for review, what they think is pertinent. This comes up all the time in expert witness testimony. He can't really get that upset about it. He did not give her the text message and stuff. He didn't. And there were texts in there where Sarah was in bad behavior, so to speak. Well, she doesn't have that to take into consideration, especially when it came to the cheating stuff and things that she said. Oh, well, we'll see. I do think Mr. J is doing a good job of getting a lot of information there for the jury to think about. This is not going to be a one-sided witness case against, expert witness case against. And he did lay the groundwork that his expert witness, Julie Werner, would have only one visit with Sarah. This expert, Miss Harper, has had plenty more exposure to Sarah, and she knows her much better. But she does admit to her having some narcissistic tendencies. And the state is doing a good job of actually letting the jury see that this could go both ways, that George also could have these disorders, that George also could have been a victim of the emotional abuse and coercive control. The bike, to me, made perfect sense. She gives him gifts. She controls it. She's the only one who has a cell phone, and she has to ask permission to use it. I do believe that he is actually getting George's case out there too. He is actually fairly showing it was not a one-sided situation, which is appropriate in this case. I believe, I'm not an attorney, but just looking at the whole thing, that's what you would want. You want the state to represent the victim. George is not here to speak for himself, and that's what the state needs to do for the family and for George, not to have him victimized by the trial for his own justice. And I think it's fair. The 9 attorneys that didn't want to bring this defense, yes, and I agree. I was going to speak on that later. But I have much more respect for the attorneys who withdraw at this moment. Even after listening to the psychologist, which I can agree that Sarah has a lot of these abuse tendencies. She definitely has some stuff going on. She has PTSD. She's not had it easy. But some of these problems existed before George. And George is a victim of her PTSD as much as she is. That's where I'm leaning. No, Mandy, no. I think the fact that she didn't review any jail documentation is problematic. It shows her character outside the abusive relationship, just like the 9 attorneys. I agree, Mandy. I agree with that. I think she needed to see that, but it's up to the defense or for her to request it. You know, she gets all the pertinent information of discovery from the defense if she's their witness. And I don't think they want that in there because it's character. And I agree with you that it would have been beneficial for her in making that kind of determination. Oh, I know the note was not to me, Mandy. The note was like to the psychologist, like you needed more information. At least that's what I think you mean. And I agree. I would prefer, if I was an expert witness, to have everything. But then again, I'm the kind of person that would ask or go get it, request it, take it into consideration. Well, then again, you know, she's the defense's witness. This is a long sidebar. There, you know, she can pretty much hear them. She does. You know, she did get kind of defensive over the wording on some things, and it's because she doesn't want anything not portrayed incorrectly. You know, she's doing the same thing that Chelsey Koepsell did. Like, you're not going to twist my words into saying something, you know, and I don't blame her. She should. She wants to stick to her opinion. But the words, if even though she said yes in the deposition and now she says no, she could have quantified that no with a change of opinion at any time. That is allowed. But he was holding her to her words, and she had to agree. Yes, she said that. And she didn't push back and say, but I've changed my mind. So now that stands, that yes, that she was that narcissistic character she did agree to. You know, which is a small thing in the long run. 3 out of 9, you know, we all can see the narcissistic tendencies, but now it's on record in something in the evidence that the jury needs to consider, which was good because before it was just in the air and they could or could not have actually referred to it. But now it's in the evidence and it's part of the case for their review when they go to deliberations. I don't think she had the PTSD before she had the alcoholism and the depression and other things, and the events in her childhood of the family deaths and then having to support people and when she was younger, those were indicated as traumatic events. Whether or not she had
the objection is sustained in part and overruled in part.
Clear in I don't mean to say she had.
You testified earlier in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that.
Now, let's talk about the February 23rd, 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition, if you care to use that.
Great, thank you. 36?
Yes, ma'am.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone.
Wow.
You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So
So the answer is no. She did not describe herself as
intoxicated, right?
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
And what points in time are those?
So she did not remember taking the videos of the suitcase or the incident in the suitcase until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night or day or night that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she has indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right. She just didn't say that. So
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours of, itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? It's just yes or no.
No.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So that's what she told me.
She said it was a good day.
Yes.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower?
Right.
And when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad. Yes.
And that, in turn, made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you recorded her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
You didn't find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important.
Okay. Then explain. Why wouldn't you ask that question?
Because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
She never described him doing anything to make her mad, but it was words, correct?
Right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
What?
And you reviewed the still photograph of the suitcase as well as the 2 videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah.
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get himself out of the suitcase within 20 minutes, she didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police?
Yes.
Do you consider Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs?
Yes.
And she stated to you there was no fight that day, correct?
That's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable.
Yes.
Correct. And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether, can you just repeat the question? I want to make sure I'm answering it correctly.
Yes,
Okay.
Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
yes,
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
And she reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that.
It didn't contrast to the autopsy photographs or report?
Judge, I object.
He is alluding to the type of injuries that he has because of their long and their deep. That's the poking that Sarah says she does. The state does not believe that she just poked him. They believe she whacked him. That the injuries that are there look more like a whack than a poke. The injury to her hand, of how hard she did it, if she is just poking into the suitcase.
You may proceed.
They do
Did
not
she indicate all
believe
this
that's what
nudging
happened.
or poking with the bat was done while he was inside the suitcase?
Yes.
She never told you that there was any nudging or poking with the bat when he was outside the suitcase?
Correct.
She indicated that she ended up flipping the suitcase over face down.
That's right.
And how she believes she could get out at that point, I don't understand.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No.
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
No.
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
Of course not. No.
No other questions?
Any redirect examination?
Briefly, Judge.
Yes, sir.
The state attorney talked to you about power and control, that an abusive partner will use power and control over the victim in a intimate partner violence situation.
Yes.
Threatening someone's dogs, is that an example of someone using control?
Yes.
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone,
Yes.
a debit card,
Yes.
Destroying a home, TVs, putting holes in the wall,
Yes.
not helping pay the rent and other bills.
So I would say that that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the questions.
Thank you. Can this witness be released?
As far as the state is concerned.
Mr. Owens?
Yeah.
Thank you, doctor.
Just allow me a moment to pack up.
Collect all your stuff, ma'am. No worries.
Sorry.
No apologies necessary.
I wonder where that leaves us for the afternoon.
Yes.
Oh, so we're on another sidebar. I guess it's going to be a minute, you know. I'm going to mute for a second though, because I need to loo. I'll be right back.
All right, members of the jury, it is 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible. Again, same instruction I've given you before.
so they are
Please
going
don't
to
conduct any
break?
independent investigation or research.
Okay.
It's the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. We'll bring you back in as promptly as possible. Thank you.
Okay. Well, this is rather inconvenient, people, but I still do need to take a break for a second, and I will be back shortly. Okay. Hopefully, their break is going to be short. But I'm listening to what he's going to talk to counsel about. I think the state might be resting.
Y'all can be seated. Let's go ahead and take a recess, a comfort break for any of us, and then we can address any argument with regard to the any other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 4:13. Okay? All right, thank you. We'll be in a short recess.
Hey there, everybody. Thank you so much for watching our Sarah Boone trial coverage. Now, guess what? This isn't Sarah Boone's first time interacting with the court system. In fact, she had been charged previously with domestic violence against the same man she's now on trial for killing. And how do I know this? Well, because we put Sarah Boone's name and location into the Truth Finder search bar, and we were able to find out all sorts of information. When we scrolled down to her criminal history, we found minor things like a speeding ticket, but also the much more severe charge of murder that she's now facing in an Orlando
Sorry,
court
guys.
right now.
Sorry,
And even if you don't work in true crime, you can find out all
let's
kinds of
just get
information
rid
on
of
Truth
that.
Finder, like
Okay,
which sex
so sorry
offenders may
about
live
that.
in your area.
I almost
Even use
made it
Truth
back
Finder
in time
see
to
what's
tell
available
Jesse to
about
be
yourself
quiet.
online. Here's the main idea. It can be
No,
hard to
save
know
us
who to
from
trust.
save
And
you from
knowledge
that. I'm
today
sorry, Couch. I
is
ran back
power.
as
So
far as
right
as
now,
fast as
you
I
can
could.
get 50% off of your first month of confidential background reports. Just go to
I'm sorry, Vicky. I had to go. I had to
truthfinder.com/LC
go.
Live and access
Like,
information on
listen,
almost anyone.
like, you know what I always say? In real life first, people. Like, come on. The same applies to me. Like, if you gotta go, you gotta go. But like, I did find this actual testimony from the defense's actual expert witness to be beneficial to the defense, definitely, as far as Sarah's mindset, and that she definitely has some issues. Definitely, this expert believes that she is a candidate of BSS, no doubt. However, I do think that the state did a damn good job of saying it goes both ways. Like, doesn't the same apply to George? And also put some credibility issues there on how far these discussions went. Sarah has never been challenged on if she's telling the truth. And that, of course, that is actually very common with psychologists and therapists when dealing with trauma and dealing with events. It's true. They don't question you. It's not an interrogation. They're not going to say, well, what did he say? Or what did he do? And then what did you do? It's a free form. It's her perspective. It's not up to them to challenge it. But it did actually put the spotlight on it for the jury that this is only a slice of the event, in that this expert witness cannot actually testify to the credibility of Sarah in the event. She could not say that what Sarah said happened is what happened. She did not have enough information to say that. And I found that to be very substantial for the state's case. And you're all laughing at me because they had to go to the bathroom. Do you guys not have to go to the loo? Like, come on. It is the state's job to infer that she's lying or prove that she's lying. But they've done a good job to prove that there's no collaborating evidence for what she said. That's what I'll say, Anna. They have proved their case that she did not let him out of the... They have proved the case that she was charged with. What this whole trial is about is whether there's an extenuating circumstance that makes her not guilty of it, even though she actually admits it happened. She helped put him in that suitcase. She's the one that zipped him up. She's the one that refused to let him out, and he died. The only thing this case is about is not those factors. Those factors she's admitted to. Those factors she's hands down guilty of. Now the trial is about the extenuating circumstance of, is there a reason why she did it that would actually cause an acquittal? Reasonable defense that I'm guilty of it, but this is why, so there's no intent, so I get to walk. I mean, that's as simple as I can put it. Exactly, Mandy. Well, it could go the Menendez brothers' way or the Gypsy Rose way. Either way, all murderers. And yes, and I am of the belief that whatever her state of mind, murder was not the answer. And I've gone on record to say that this defense is more a sentencing mitigation than it is a an acquittal. I don't think it should be used for acquittal. I think it could be used that if they say, if the defense has adequately proved that she suffers from battered spouse syndrome, which they have, it's on record. They do have evidence out there. It's up to the jury on what they believe. If that is sufficient to say she's not guilty of murder too. Now, I don't know if they can automatically bring it down to manslaughter, but we're going to find that out when the judge decides they do the jury instructions. When they actually hammer all that out, which I believe we'll be doing after the rebuttal, they'll be hammering all that out, or actually before the rebuttal. They should do it before they close out closing statements. The rebuttal can happen, and before closing statements, they should have agreed on what the jury will be advised. And we will find out then on whether they are allowed to actually consider dropping the charge down to manslaughter to consider her guilty. And in a way, that's kind of a sentencing mitigation, isn't it? Because you started 22 and a half years for murder too in Florida. But like I said, this whole thing with the battered spouse syndrome defense, it's really messy in Florida. It goes both ways on state and defense on what can and cannot be. I'm just uncomfortable with the way it gets used in occasionally. I do think it should be a tool for victims. It should. Victims of abuse should be able to state what their state of mind was at the time. It's just like, not guilty by reason of temporary insanity. Now, in some states, that's still viable. Okay? In some states, you can be not competent. Oh, gosh, Mindy. I just said the word incompetent, and Lori Vallow's face just jumped up in front of me, like right in my head. Because did you know that they just ordered a competency hearing for her? Oh, she has to go get an evaluation, and everything's stalled on her trial. Yes, everything is stalled. Yeah, not going to court yet. We got to see if she's fit to stand trial again. It's like repeat. It's like wash, rinse, repeat. But anyway, same kind of thing. If you're allowed to say, okay, it was self-defense because that was a crime of passion. It's self-defense because, I temporarily lost my mind. I had a psychotic break. These are all mitigating factors. Yeah. Oh, she's a loon. Yeah. Yeah, I do. Yes, I do. Yeah, don't even, people. I will actually tell you what's up with that trial, but I ain't doing anything live with that one. I ain't giving Lori any airplay. Not like that. Yeah, that's what I don't get, Rocket, because she said the mitigating factor was his fingers being exposed, but now she says it's what he said, and yet she has not, to this date, told anyone what he said that set her off. I did. I had heard that. Yeah, I did hear that call. Do you mean the phone call, Mandy? Yeah, it was very upsetting. Is that the old one? It's not new, right? Or is it a new one? I don't know. That is funny, Rocket Couch, but I don't know. I actually this is actually very my brain is abuzz with the implications, the legal implications of this case and how it will be used in the future for both sides. I wasn't kidding when I said this is going to make case law for a very long time. It is. It is. It's a new one. I'm going to want, yeah. Okay. I'll go look for it. He's got a channel, right? Mandy, yeah. I thought it was the same one. That's why I didn't watch it again. But if you wanted to punch your screen, I don't know if I want to hear it. I'm already in a state with this one. I think I need to calm down first a little bit. Get my Zen equilibrium back a little bit. But yeah, this one's definitely. I'm glad though that I did this one live. I think this was important, this one. I think we all have expressed opinions and learned a little bit more about the law in Florida and how they're using this defense, something we weren't aware of before. So I think it was well worth the time and getting up early. Thank you, Mandy, for that. We appreciate it. I will save it for later. Thank you, Boo. Thank you. I hope when they come back that we find out what the rest of the week is going to be like. I already had tomorrow's stream set up. I'll probably change the heading based on what we're doing because I thought Miss Julie Harper was showing up tomorrow. But I will definitely have to change the title of that one. Maybe change the title of this one. But the stream is up. I am going to be here at 8:45. As long as they're here at 9 o'clock, I'm going to be here. But it does look like we may get this to the jury by the end of the week. Today is only Wednesday. Happy hump day, by the way, people. Yeah. Yeah. Valo is crazy. I don't know how they actually, with her beliefs and everything, found her competent to stand trial the first time. I really don't. She's got new appeal attorneys, doesn't she, Mandy, in the first trial? I think I saw that somewhere. I am going to have to do a true crime. It's going to be a long one next week. I might have to do 2 to catch up. Like, there's been some stuff going on. Like, not to change the subject, but actually I do need to a little bit. Like, I think, Let's just see this, though. Anna has it. Okay. BSS is so new as a defense, and people are not aware that it exists because of the newness of and the diagnosis of it. Yes, true. And here's the problem with it. We now have law, and they're using it, but we've got no standard procedure for diagnosing it. And I find that to be a problem. How do we base law and procedures in criminal cases like this when there's no standard by psychologists and other experts to actually diagnose it? Do you see what I mean? To me, that's a big problem. And I think the fact that the state brought that to light is going to be important for the jury to consider. I know if I was sitting on the jury, that would be a consideration of mine. This is one woman's opinion with no standard. And we're using it in a criminal case. We're basing criminal law and procedure on a defense that has not been adequately firmed up. And it's not even in the diagnosis book. It's a mitigating factor. And it still has no standards. I think they jumped the gun on putting it on the books. I'll be honest. It's an uncomfortable situation, and I'm not even a lawyer. Can you imagine how the lawyers feel? I guess depending on what side you're on and how you want to use it, the fact that there's no standard is a good thing or a bad thing, It's just what they call it. Believe me, we have issues with the name too, Damien. But what I will say is the law often does stuff like that. Like, when they increase the statute of limitations for women and children, and they forget that men also get abused and need the right, or they name certain laws and legislations like certain ways as if it only pertains to one particular type of person or sex or involvement. That's a big problem. Language in the law needs to be a little bit more curtailed, not curtailed, but specific to how it can be applied in all things. Just that it's BSS, it should actually be intimate partner abuse syndrome. How's that? Because it evolves in couples, all types of couples, married or not, but intimate relationships, man, woman, woman, of all natures. And it is when there is more than one instance of abuse and battery.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Dick Estar on behalf of the state.
William J.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone. Kevin Beck for Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Yes.
Yes, sir.
Mr. Henderson.
Yes, sir.
Yeah. Judge, there's two orders that I'm going to be requesting the court to take judicial notice under 90.202 sub 6, and the orders of no contact. I have copies of the certified copies of the orders. May I approach?
Yes. State, have you seen them?
Doesn't change my position.
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Doesn't change my position.
Understood. Okay. You can bring them on up. Thank you, sir. Court has been provided no contact orders issued in case number 2019 MM5062 on or about June 16, 2019, and a no contact order in case number 2019 MM5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any arguments as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of Regional Director Dr. Harper, saying that an element of control is talked about greatly by the state. I point out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing on this Boone. These show that they were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Okay. Response.
So in regards to the judicial notice aspect, we don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking what are the hypothetical things that we rely upon in making these determinations as an expert about whether there's battered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Moon that there was pretrial no contact orders and violations of them. It's not a fact in dispute. It's just that doesn't mean that the paperwork comes in as evidence. So that's our objection is it's irrelevant and hearsay just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself because it says that the court can take judicial notice. So that's the foundationary part. And it's not hearsay. It's an order of the court. We're in a case where we've gotten evidence of past
If they bring it
domestic
in,
abuse. There was evidence of it.
are they going to be allowed to bring in the end result?
About control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
But how's it not hearsay? Just because it's a court record, it's still out of court statement. It's certainly being offered for the truth of the matter asserted, no contact order.
Judge, that's why we have the thing that the court could take judicial notice of. There are certain things that court.
But the case law says you can't utilize judicial notice to get around hearsay.
Exactly, Mr. Henderson, and you know this.
I know 9202 says that
Don't
I
you love
may
how he
take
just
judicial
goes
notice.
silent when he's hit with
9203 says that upon sufficient notice being provided, which the state is conceding based on their argument,
Kraynick?
the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 Southern 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
I would just like to add that this particular case, if these do get entered, this is not going to be good for Sarah if the whole case becomes public. Sarah wanted the no contact altered to say he could still live in the house because she wanted him back in her life. She didn't want him away. She didn't want him, the no contact was either keep away or not. When she went back to the judge and said, can't you just tell him to behave? Basically, that's what the summary says. Like, just tell him not to act out. I want him back in the house. They did that, and the very next day, the prosecution dropped the charges against George. That Sarah brought. Sarah did the first no contact, and I think George may have. Then the second one, I believe, is the altered one. If it's the case I'm thinking of, yeah.
I'll start this way first. One of the exceptions to the hearsay rule is business records exception. So if it's a business record and it's kept in the normal course of business, then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule. However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record.
But do you understand that this judge doesn't want to take judicial notice of it based on what he's reading?
90.2026 can take judicial notice of court orders. This is a court order, it's certified. I think it's an exception to the hearsay rule. Also, I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, you wrote.
Any other argument, state?
The fact that there was a pretrial court order of no contact between them, it is going to come in. I mean, on one of the body worn cameras, Mr. Torres is like, well, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay. All right. Thank you very much. State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235 at pinpoint 253 by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order, and the requisite requirements for a business record under 98036 subsection A have not been met, nor has there been a certificate from the custodian of records as to those things, as required by paragraph Section 6, Paragraph C, and the timeliness of a certification. So
I'm sorry.
I
I'm sorry.
cannot accept judicial notice of these two documents,
This
even though
this judge is glorious.
the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
You should have read the statute a little farther, Mr. Henderson. You got to read it all, not just the part that you think that I got you.
Judge, we do have the clerk of court subpoenaed. I don't know where they are. I assume they're somewhere in this building. I believe they sent some message to us back before the hurricane about what they needed were to come, and we said to be continued. So we haven't gotten back up with them yet. So it would take me some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period.
Okay,
But we haven't followed back up with them. This came up
sure.
late.
I'll give you an opportunity to do that.
I don't know whether you could just go ahead and send them.
Why didn't they do that before they brought this forward?
And let me see if we can find the clerk.
It's pretty
maybe in the
clear.
morning, and then we can rest in the morning, and then the state has Dr. Warner. It's probably-
You don't get to reopen your case.
I'll give you that opportunity.
Okay.
Absolutely. If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or
I
a
think
person
it is.
to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yes. 3rd floor? Sure.
I suggest we go ahead and let the jury go. It's 4:30.
Okay.
I don't know how long it's going to take to do that, but we could present that in the morning and then rest in the morning and then they.
All right, that works for me.
Judge, I'm not going to make some poor employee come in and do that. I was conceding the authenticity. I don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by it's a public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
I don't want to punish some poor clerk.
Okay.
Because the
I won't
defense is
object to
leaving.
coming in, but it's a slippery slope for other records. We'll see what we can do.
Okay. All right. So the state is still maintaining its hearsay objection. I do find that it is relevant.
I don't make my part.
So then what do you want to do, Mr. J?
I'm stipulating to, if the hang up for the court and the defendant is that they believe a clerk in the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Okay. All right. Fine. Then based on the court, on the concession by the defense, by the state, excuse me, do you have any other objections with regard to these two non-contact orders? Mr. J?
No more.
Okay. For the reasons previously articulated,
Because he knows he can count.
I do find it's relevant. The
effectively,
state has
and it's
withdrawn
not
its
gonna go
hearsay
well.
objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, can you pre-mark them and then we'll identify them, please?
Looks like we're going to end early. I do like him even more now. And I give Mr. J mad respect for not wanting to drag somebody in here for something unnecessarily. Because these people didn't dot their I's and cross their T's. If you're going to use it like business towards them in 90.3, you should have read the rest of it on what you needed to acquire to make that exception.
No contact order in 2019 MM 5062 dated June 16, 2019 has been pre-marked as AB. And the no contact order in 19 MM 5114 dated June 19th, 2019 is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her, why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the court, with the defendant. But we do need some time with her.
Okay. All right. So then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow, and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. The state, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Warner will take long on our part. I'm not sure how long it will take on their part. Then there's about...
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
If this direct is 30, my cross is probably going to be 30.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body-worn camera and from the phone extraction.
Mm-hmm.
And then reading a good bit of phone text messages with the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings, or are we going to proceed with closings Friday morning after had the opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
Oh, interesting.
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on that spouse that would have been requested.
Okay.
There's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction on battered spouse, and whether or not you want to consider one of the local courts, the Palm Beach County case that I mentioned before with Dr. Bannon. There was a special instruction in that case. And then we've got some from other states. I don't know what the state's position is going to be on that. So we may
Has a draft of that been circulated yet?
not to the court.
Okay. All right. All right. So here's what we're going to do. Okay. Let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F. With regard to those, the court will have Ms. Barrios email you all. She just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before 9.
Okay.
Judge?
Yes, sir.
There was one thing. The state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read the motion. and the proposed instruction, I have no objection to it.
Okay, all right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements, filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state, defense, state, have I read that correctly?
I believe so, without reading myself.
And defense, you have no objection.
No objection, Judge. And it's my understanding there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it. So I will add this to the red line to be set out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am, there's a form instruction. It's 3.9B, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Okay. Let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you.
Okay. Anything else, state, we need to address?
Thank you.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
Well, we're not actually adjourning much earlier than a full day since it's almost 5 o'clock. While they wait, I just want to thank you all for being here. I think when this is over, I'm going to hightail it and get to the thumbnails in the actual timestamping of this for everybody that wants to go back to the replay. And I will be ready in the morning. It sounds like we're going to have an interesting day.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
I do.
Thank you. Y'all can be seated. Members of the jury, good late afternoon, early evening, I think. Again, could you just raise those hands, confirm that you complied with the court's instructions? All right, record reflect all hands have been raised. Members of the jury, it's 4:43. We're going to go ahead and break for the evening. I'm going to ask you to be back here at 9 a.m. tomorrow morning. We'll continue with evidence and testimony presentation by the defense. and then we'll proceed accordingly thereafter. I want to read you the same instruction that I've read you multiple times over the last week, and I beg your forgiveness as you hear it again, but I just have to keep reminding you. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, again, I thank you for your time, your sacrifice, and your attentiveness in this matter, and we'll see you tomorrow morning at 9 a.m. Y'all can be seated. Thank you. Anything else we need to discuss, State, before we go into recess for the morning? Defense, anything else? No, sir. All right, we'll see you all tomorrow morning at 9 a.m. Thank you very much. Court's off the record.
Okay, so it's going to be also for the night, I believe. I'm going to call it here. They're actually going to be talking to Sarah a little bit and then adjourning in the morning. They can only talk to her until they come together to leave, but they'll try to get some stuff done. But I think this is a good time for us to actually call it a day, let everybody get a good rest, and come back in the morning. We had a lot of testimony. It was really quick in the morning, boom, 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 but it was very long in the afternoon with Julie Harper. I will want to say this. She was definitely the expert for the defense. She was hired by the defense, and she did a good job for the defense. But she did not really want to hear anything about anything that Sarah said. She's definitely on the victim advocacy. She sees Sarah as a victim, and she just, she stayed in her lane in regards to that. But I do think the prosecution made some headway in opening the eyes of the jury as to the other side of it, even with this witness. I think Mr. J was on his game today. He was. And, the defense is doing exactly what they're supposed to do. They've got to throw everything out there and give her the best defense that they can. And they have been trying. My issues with them is in preparedness, dotting the I's and crossing the T's and having things available. They're doing a little bit better on that, but not much. But that's a pet peeve of mine, but I'm no lawyer, I don't know what it's like to have a client. I'm sure it's very hard to be a defense attorney. I'm positive it's extremely difficult to be a defense attorney and deal with the client. It's not like prosecution. You get to do it all without a client. The client, you don't deal with them. The client is the state and the victim, and you're not dealing with them every day the way that defense attorneys are with their clients. So I give them a little grace there. They did come on late, but there are 3 of them and 2 paralegals. And come on, paperwork is paperwork. Timelines are timelines. Dot your I's, cross your T's. If you're going to ask the witness about a property on a list, have the property list. Don't look like an idiot looking for it and then not have it. That was dumb. They are pro bono, but they're private attorneys. They're not in the public defender's office at all. Hey, Godless Granny. Going to be very interesting tomorrow. You missed the whole thing for today. Yes, you did. But if you want to join me at any time tomorrow, you just shoot me a DM. I'll send you a link for whenever it is convenient for you. I love when you come by. But I'm actually wrapping up for the day. I'm going to jump ship and get a good night's rest tonight. Get my stream timestamp. But the expert witness of the psychologist actually did testify today, and it was quite interesting. And I think that you're going to like this judge, Godless Granny. So if you catch any of the stream, which I do have everything in the playlist, I've got all 4 days up. I'm going to timestamp this one. But I would love to hear what you think of this judge. I'm falling for him. I'm telling you that right now. But and the other attorneys too. I just like, looking at that. Not that I'm not legal. I'm not judging them on that. I'm just judging them on the perception of them, the appearance that they give, and how the jury might react to some of it. You know what I mean? Like just as a juror. So on that, everybody, I am going to say goodnight. And I will see you all at 8:45 if you're here. Grab a cup of coffee, come warm up with me before we start rolling at 9 o'clock. Sounds like this judge is staying on schedule, and he's going to push for everything to get done. We should actually finish the defense case, start on rebuttal, and actually do jury instruction motions in conference in the afternoon. Well on the way to closing statements for Friday and giving this case to the jury. So there you go. Thank you all for hanging out with me, and I will see you tomorrow.